We don't control our cameras, just so you know. Like in the last meeting, somebody had to turn it on for us and off. So if that, whoever that person is, the Wizard of Oz, if you could do that, that'd be great. Thanks.
Most attendees should be able to turn off, but I can do it for you.
I just was able to do it. That's exciting.
And the reason for that is because it's hard for the court reporter who's here to see who's speaking if everybody's camera's on at the same time. Okay, I think we have Alderman Nguyen, we have Clerk Reed, Alderman Rainey, looks like she's connecting. There she is.
Kelly, may I ask you, did the board decide on the order of the cases to be heard already?
No, the agenda's been posted and I believe the board has not decided the order yet.
Okay, thank you.
Mhm. Okay, Mayor, I think we're ready when you are.
Okay, thank you. All right, welcome everyone to the Thursday, December 10th, 9 a.m. Municipal Officers Electoral Board of the City of Evanston. We are resuming a meeting that started on Tuesday at 9 o'clock. Was it Tuesday or Monday that we started this?
Monday.
Thank you. So on Monday, that started on Monday. And so we're going to resume. So I am going to call the roll so we can get this meeting resumed. Clerk Reed.
Here.
Alderman Rainey. Alderman Rainey is here. She's muted, but I saw her wave her hand. She's on camera. All right. In our alternative to hear a case where Alderman Rainey and Reed have to sit out is Alderman Nguyen. Alderman Nguyen. Okay, great. So we have everyone here. We have quorum. This is a formal process, so we do have a court reporter with us, and that is Tina Hickey, who is with us on Monday as well. So welcome, Tina. She will be recording all of the statements that are made here in this meeting. In case anyone chooses to appeal, that will go to the circuit court. Everything that occurred at this meeting.
Excuse me, Mayor.
Yeah.
You are breaking up, at least to me. I don't know whether you are to others as well.
Yes.
Oh,
Yes.
boy. That's not good. That's not good. Is Luke Stowe with us? He is. Luke, I don't know if you have any tech people here in the city hall. I'm at City Hall, so that we have one official that's here. And I'm just wondering if the connection that I have is a weak one. I'm working off of the public Wi-Fi. If putting me on the city one makes it more secure or a better connection.
Hi, Mayor. I can see if I can have someone stop by, but I'm wondering if maybe you should disconnect and reconnect to the meeting and see if that helps.
All right, let me do that. I'll be right back, everyone.
And just a reminder for everyone, if you could go ahead and turn off your video and mute, that would be great. Thank you. Except for the board members and Ms. Hickey.
Well, in the meantime, happy first day of Hanukkah to everyone who celebrates.
Okay, Mayor, do you want to try that again now?
Okay, well, welcome everyone to the Thursday, December 10th, 2020 Municipal Officers Electoral Board of the City of Evanston. Can you all
That
hear me?
works perfectly.
Better this time? Okay, all right. So we're back. We're not going to cover all the things that I mentioned before. I was saying that Tina Hickey is with us. She's a court reporter. She will be transcribing this meeting. When we do get to the public comments, which is at the end of this meeting, those are not transcribed by the court reporter, just so everyone knows that. We did do a roll call. We have all of the board here, as well as an alternate, which is Alderman Melissa Wynn, to help hear one of the cases. Item number 3 on our agenda, I do want to recognize that due to the COVID-19 pandemic and the ongoing restrictions as set forth by Governor J.B. Pritzker's executive orders, and due to the City of Evanston's declaration of emergency and pursuant to the amended rules of the Illinois Open Meetings Act, the board finds it necessary to conduct the meeting virtually using the Zoom platform. So I wish we could all meet in person, but because of the pandemic, we are going to have to meet virtually. Per those rules of the governor, one of us is in the Civic Center, City Hall, and that is me. So I am here at the Civic Center today. Is there a motion to conduct this meeting virtually using Zoom?
So moved.
Okay.
Second.
Is there a second? Okay. All in quick roll call on that. Clerk Reed.
Aye.
Alderman Rainey.
Aye.
Alderman Nguyen, I know you're an alternate, but for the meeting you're going to hear, are you okay with that?
Yes, aye.
And I'm an aye. Okay. All right. So we're now going to move on to the cases that are before us. I know the parties have done a lot of work over the last 3 days. My expectation today is that we are going to hear these cases, that there's not going to be motions to continue this later. We are in an expedited time frame because this is an election matter and we need to get these on the ballot. And if there are appeals, there needs to be time for the circuit court to hear these cases. So I believe all parties have had the time, although I realize it's all moving quickly, to put their motions together and all of that. I am going to ask our counsel to the board, Kelly Gandersky, to actually run the proceedings of each case as we go through those. With us just to make sure we're following all the right procedures. I do want to also make sure that we have into the record all of the documents. Everyone today is going to have the opportunity to present their cases. Okay, so even though I know on Monday, I think the first one did it, and then we offered a continuance on that one because Mr. Young had not been properly served and asked for some more time to be represented by an attorney. We're going to start fresh with each of these cases. We did adopt rules at the Monday meeting, so those rules of the municipal board as amended are in effect for this meeting. Any questions or comments from the board members before I turn it over to Ms. Gandersky? Alderman Rainey.
Yes. Haggerty, I'm assuming when Attorney Gandersky said that the agenda has been posted, it is the same agenda as for our original meeting, right?
I believe so. Ms. Gandersky, could you just confirm that?
It's not the exact same because we adopted rules and we had other adoptions on
But
Monday.
the order of the cases,
The order of the cases remains the same.
thank you.
Okay, so the order of the cases remain the same, although what we did do last time is we did move up the Tom Osser versus Shelley Carrillo. We moved that up so that Alderman Nguyen didn't have to stay for this entire meeting until we got to that item on the agenda. Is that okay with the board that we do that again today?
Staying anyway, I think.
Okay, all right. So let's go ahead. What we're going to do is we're going to hear case number 20 MOEB-EV-05, Tom Osser et al. Versus Shelley Carrillo for the office of, we believe, the 8th Ward Alderman. That's going to be the discussion. For this particular case, it is going to be heard by Alderman Nguyen and myself. 2 members of the board make quorum. Alderman Rainey and Alderman Reed are both candidates for the 8th Ward and won't be participating in this case. So with that, I'm going to turn it over to Ms. Gandersky to lead us through this case.
Good morning. Is counsel for Tom Osser and Nicole Mitchell-Hall here?
Yes, good morning. Andrew Finco for the objectors.
Mr. Finco, please spell your name for the court reporter.
Andrew, A-N-D-R-E-W, surname F-I-N-K-O.
Okay. And do we have Ms. Carrillo or her counsel here today?
Good morning. Yes, I'm here. Shelly Ann Carrillo, SHELLEYANNCARRILLO.
Okay. Thank you, Ms. Carrillo. Thank you, Mr. Finco. Ms. Carrillo, do you have counsel or are you representing yourself today?
Representing myself.
Okay, very good. I'm just, as a preliminary matter, I'm going to make sure that we have received all pleadings in this case. So I have the appearance form of Andrew Finco. I have the objector's petition. I have the motion to fill vacancy and designate 3rd electoral board member filed by Mr. Finco. I have Ms. Carrillo's motion to dismiss the objection. And I have the objector's response to motion to dismiss and memorandum of law in support of objector's petitions. Do we have all pleadings in this case?
Yes.
Yes, my understanding.
Okay. And Mr. Finco, do you intend to call any lay witnesses this morning?
No.
Okay. Ms. Carrillo, I'm going to go ahead and swear you in. We don't swear in Illinois licensed attorneys only because they are already under oath to always tell the truth before tribunals. So this is no disrespect to anyone who's not an attorney, but attorneys are always sworn to tell the truth. So Ms. Carrillo, unless you are an Illinois licensed attorney, I'm going to swear you in.
Understood.
Okay, please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, let the record reflect. Ms. Carrillo has been sworn. Ms. Carrillo, do you plan to present any lay witnesses this morning?
No, I do not.
Okay, very good. So as a preliminary matter.
Ms. Gandersky, can I just ask one question? Do we have to move a motion to move into the record all the 5 documents that both parties, acknowledge have been submitted?
As a preliminary matter.
Or is it just acceptable that you have reported those documents and that the 2 parties have acknowledged that those have been submitted?
I'm going to ask the board that since the documents have been filed with the clerk's office, that they are on record as filed, and we intend to give all of the pleadings to the court reporter as part of this record. So I don't see the reason to move all of these into evidence today.
Okay, thank you.
Okay, and is that so stipulated by the parties?
Stipulated, yes.
Yeah.
Andrew Finco.
Yes, Shelly Ann Carrillo.
Okay, very good. All right, as a preliminary matter, I do think we need to address the motion to fill vacancy and designate 3rd electoral board member. Mayor and Alderman Nguyen, this was filed by Mr. Finco on behalf of the petitioners, objectors, and essentially Mr. Finco is requesting that a 3rd electoral board member be designated to hear this case. As it has been discussed previously, A quorum for a board, electoral board, is 2 members. However, does the board wish to entertain the motion to fill vacancy today?
So today, the board does not wish to entertain that motion.
Okay, so let the record reflect the motion to fill vacancy and designate 3rd electoral board member has been denied. Is that true, Alderman Nguyen, as well?
Yes, that is true.
Okay, all right. So, and both electoral board members agree the motion is denied. Moving forward, we have.
Excuse me, Ms. Gandersky. Just wanted to make a point before we proceeded. I was not given a chance to present the motion, but I understand that it's denied. But I would like to note a standing objection to further proceedings, that by proceeding with a 2-person board, I am not waiving the request for the 3rd board member, which is mandated under section 10-9 of the election code. Thank you.
Understood. Your objection is noted for the record, Mr. Finko. Thank you. Okay, so we now have I know we started proceedings on Monday. I think in fairness to, and also to refresh the board's recollection, I would like to give another opportunity for the objectors to present their case in chief for 10 minutes. Ms. Carrillo, you will receive 10 minutes thereafter, and you will also be able to cross-examine any witnesses that are presented. Same for you, Mr. Finko. So with that said, I would like to start the clock at 10 minutes. Ms. Ruggie, are you keeping time?
Yes, I am. Ms. Candidacy, I have one question.
Yes, ma'am.
After the 10 minutes, are we allowed any time for closing remarks?
We can do a 2-minute rebuttal.
Okay, thank you.
Okay, Mr. Finko, you have the floor for 10 minutes.
All right. Good morning. Thank you, members of the board. The objectors in this objection asserted that the candidate's nomination papers do not identify with sufficient specificity the office for which she gathered her paperwork, for which she obtained signatures, and for which she swore in her statement of candidacy that she was qualified to hold. The memorandum that I submitted summarizes the law on that, and in Article 10 of the Election Code governs, and it defines that a candidate must state the office for which they are seeking to be placed on the ballot. The candidate's nomination papers were circulated with the simple designation of alderman, and that the voters were simply signing the portion at the top which referenced alderman without a designation of the ward. The statement of candidacy similarly identifies the office as alderman and does not identify the ward. Same for all of her paperwork. There's not one reference to the ward for which she is seeking to be placed on the ballot. The election code identifies that the office must be stated, and it must be stated on the nomination papers. And the reason for that is because if there are multiple vacancies on the ballot, then the voters will know which vacancy that candidate is seeking to get ballot placement. That there's also an issue with the clerk request, where they put the clerk of Cook County, where they place this candidate on the ballot as to which election. The case law is relatively clear. There are a few cases that are very much on point, that are very similar, where there's more than one vacancy. That renders the paperwork invalid. It renders the paperwork not in compliance with the election code, and because there is a substantial basis for confusion. Specifically, the standard is no basis for confusion as to the office, and what we look at is the paperwork itself, because the voters, given the way that wards are mapped out, many voters don't know exactly where their wards are. They may not know, or sometimes what they're signing for. So where there is more than one vacancy, then the paperwork is invalid, because as a matter of law, there is a basis for confusion. And that's cited, the Lyons MV Party versus Lions Municipal Officers Electoral Board, 407 Ill App 3rd 104. That's at pages 6 and 7 of my response and memorandum of law. As an electoral board, this electoral board is charged with the review of the nomination papers, and the review is in accordance with the election code and prior decisions of the appellate court. The appellate court has said that where there is more than one vacancy on the ballot, the candidate must designate which of those, and vacancy refers to places that are being elected. So where there is more than one possible ballot place on the ballot, the candidate must designate which of those spots the candidate wishes. The nomination papers herein are deficient because they do not identify that particular ward, and there's 9 wards that will be elected. There's additional cases. Salgado versus Marquez, which says where the office specified can refer to more than one vacancy, there is a basis for confusion. So aside from the electoral board decisions that were also cited in the objector's petition they're not binding, but there's certainly an indication of interpretation of the election code. The appellate court cases are binding on this appellate court, on this electoral board, and I would ask that the objector's petition be sustained.
Okay, thank you, Mr. Finko. Ms. Carrillo, I did note that your response is really more of a motion to dismiss. So procedurally speaking, I would like to address that. And then maybe Mr. Finko, I'll have you respond to Ms. Carrillo's motion to dismiss. So there may be more time in this case for that reason, because I want to make sure that Ms. Carrillo has enough time to present her motion, and then Mr. Finko, you have enough time to respond to that as well. Ms. Carrillo, I'd like you to present, you have 10 minutes to present your motion to dismiss and any response to Mr. Finko's arguments. So we will go ahead and set the clock. Ms. Ruggie, are you ready?
Yes, I am.
Okay, Ms. Carrillo, the floor is yours.
Morning. Thank you for the board to hearing my case today. I'd like to cite a previous case in Samuelson 2012 Illinois Appellate 1st 120581 and in King versus Justice Party 284 Illinois Appellate 3B 886 in the 1st District 1996. The court found that when a deviation from the election code is minor or technical in nature and does not affect the legislative intent to guarantee a fair and honest election, the deviation will not render the entire petition invalid. My case is in substantial compliance with the requirements of the statute. There is no likelihood of voter confusion and no threat of the integrity of the election process and no likelihood of confusion by the ballot preparation officials. The objectors in this case have a burden of proving their case by a preponderance of the evidence, and they have simply not done that. And as a result of the objector's petition should be denied and my name placed on the ballot. The cases cited in the original objection petition, as well as his response to my motion to dismiss, all display the same unpersuasive case laws that simply do not apply here and are not binding on the Evanston Electoral Board. For example, in the case of Haynes versus Pritchett that Mr. Finko attached to his response, the facts in that case are not in line or on point with the facts of my case. In the cited case from the city of Chicago where voter confusion is at issue, they state the following about their reasoning for requiring that a ward be listed on the nominating petitions. It is not enough in a city which elects 50 aldermen, not at large, but ward by ward in 50 separate wards to declare that one is a candidate for alderman. But in my case, in a city like Evanston, where we have a population of only 74,000 and only 9 wards, versus a metropolis like Chicago with 2.7 million people and 50 wards, the sheer differences in size is why voter confusion is more likely to happen there. This particular case law does not apply to my case and is not binding, and there is simply no basis for the likelihood of confusion, and this case law should not be adopted in Evanston. I was served by the Evanston Electoral Board, and even the case number in itself includes office of the 8th Ward next to my name. Additionally, I obtained 25 signed and notarized affidavits from the same voters that originally signed my nominating petitions. These same voters are legally registered voters in the 8th Ward and represent a cross-section of the signers of my nominating petition for candidacy for the alderman of the 8th Ward and that asserts that they were absolutely not confused at the time of signing my original petition. It is clear to the voters of the 8th Ward that signed my petition that I'm running to be their alderman. As a duly legal and qualified voter in the 8th Ward and only qualified to run in the 8th Ward, I urge the board to consider the case law in Siegel versus Lake County Officers Electoral Board that states the following: a candidate's access to a place on the ballot is a substantial right and is not to be lightly denied. I have demonstrated more than minimal appeal by obtaining more than 127 legal and valid signatures required for my nominating petition. The citizens of the 8th Ward know the office I'm running for, and it is offensive and insulting to those very same voters for the objector's petition to state that I purposely set out to mislead or confuse them. My documents are legally and factually sufficient and compliant. In the Evanston Municipal Code, it states that the City Council is composed of the mayor, city clerk, and 9 aldermen, making the title of office alderman, as does the election code in which our municipal code refers to. The code does not refer to ward alderman. The wards in Evanston are determined by address, and my petitions clearly state my address. I did not leave the 8th Ward while collecting signatures, and the signatures obtained reflect that. Over 90% of the signatures obtained are legally registered voters of the 8th Ward. Thank you.
Ms. Carrillo, I would like you to address your motion to dismiss as well. You did make a motion stating that the objectors, I guess, for lack of a better term, lack standing. Can you
Correct.
please address that for the board?
Yes, the objector's petition lacks standing as Tom Osser, Tomoser, and Nicole Mitchell Hall are not registered voters of the 8th Ward. I was also served insufficient and incomplete objector's petition. It only included 3 pages. There is no signature page, and it also does not state the relief that they were requesting, as well as the fact that statements made in the objector's petition were untrue and inaccurate, and service was insufficient.
Okay, thank you, Ms. Carrillo. Is there anything else you'd like to add at this time?
Not at this time.
Okay, Mr. Finko, can you please, let's reset the clock for 10 minutes since Ms. Carrillo did have a motion to dismiss. You'll have up to 10 minutes to respond to the motion to dismiss as well as her counter arguments. Ms. Ruggie, please go ahead and reset the clock.
Who is speaking next?
Thank you. Andrew Finko, F-I-N-K-O for the objectors, Osser and Mitchell Hall. As I demonstrated in the, well, first of all, I think in a motion to dismiss, it's the move-on's burden of proof. So the move-on would need to show that the objectors here were registered at a different address, for example, or perhaps registered somewhere, outside of Evanston or whatever. But she has not met her burden of proof on a motion to dismiss. Nonetheless, I have asserted I've attached in the response the voter registration for Tom Osser. His full name is Thomas M. Osser, and he is a registered voter at the address listed. He is registered in the 8th Ward, and I have attached the voter registration for Nicole M. Hall, and her middle name is Mitchell, but same person, same address. She's registered in the 5th Ward in Evanston. There were 2 objectors because we weren't sure of the paperwork, based on the paperwork, which ward Ms. Carrillo was seeking to be competing on the ballot. The objectors are duly registered. The perhaps concern about using the nickname Tom versus Thomas, or Nicole M. versus Nicole Mitchell Hall is not significant. I think those are acceptable, as I asserted in the response, that if a candidate for the ballot could run as Tom Osser, then the objector could certainly be an objector using the name Tom Osser. There's no confusion there. I believe, Ms. Carrillo's documents that she attached to her motion to dismiss her exhibits similarly confirm that both Osser and Hall are registered at the addresses they've listed. Section 10-8 imposes no further requirements upon an objector other than being a duly qualified registered voter and stating their purpose, which is stated and was not raised in the motion. As far as the service goes, the objectors did not affect service. That was through the city of Evanston. Clearly, 3 copies of the objection petition were filed. It's unclear as to how perhaps, Ms. Carrillo may have been missing a page, but the clerk's office accepted 3 copies, and we would not be here if there weren't 3 copies. So that's, and then the same thing with the service issue. At this point, the objector's petition is online. It's publicly available. Ms. Carrillo certainly has copies of the full objector's petition, and she understands that. Similarly, service issues have been waived because we are here, we are proceeding. Thank you.
Okay, very good. Ms. Carrillo, I'm going to give you the last few minutes here to wrap up any counter arguments to that. And so please go ahead. Let's give you at least 5 minutes to respond, okay?
Sure, thank you. The attorney states a few things that are restatements that I have already denied and proved in my denial and in the motion to dismiss. The Illinois Election Code actually requires a full name and strict compliance, and Tom Osser did not meet those requirements to file an objector's petition by placing the name of Tom Osser on that petition. And as far as the copies, it's not a matter of where they're available, it's a matter of what I was served and what was turned into the city clerk. I do believe that I've proved my burden of proof, and I'm not a lawyer, so I'm doing my best here. But I do think that the objector's petition should be overruled and dismissed.
Okay, thank you. I think we'll all agree, Ms. Carrillo, you may not be an attorney, but you did an amazing job. Thank you, Mr. Finko, as well for your very organized presentation. So I believe that wraps up argument for the parties. At this time is before the board. I think procedurally what we should consider first, the board should consider first, not we, the board, is Ms. Carrillo's motion to dismiss the petitioner's objections based on her arguments that Tom Osser may not be Thomas Osser, registered in the 8th Ward. I think I heard Mr. Finko state that Ms. Hall is a resident and registered voter of the 5th Ward, so I don't think there's any material fact that that's the case. So the sole issue before the board is whether the motion to dismiss should be sustained based on the fact that Tom is a nickname or a shortened abbreviated name of Tom Osser, whether that meets, substantial compliance before the board in terms of an objection, and addressing Ms. Carrillo's arguments that she was not properly served by the objector with the full 3 pages of the objection petition. So that is the first question before the board, is whether Ms. Carrillo's motion to dismiss the objection should be sustained.
Is there any discussion, Alderman Nguyen? Yes.
Well, I did carefully read all of the papers in this instance. And I would, my view is, as Attorney Finko said, the law does permit candidates to run using nicknames or shortened names. And I do think, in fairness, that someone signing their name with a common nickname like Tom for Thomas shows substantial compliance. So that part of the argument to me does not hold. So I believe that Tom Osser was a legitimate objector filing as Tom.
Yeah, I concur with that. I remember when I ran 4 years ago, we had a whole debate that they wanted to go with Steve Haggerty because that's how I'm known. And then there was the whole question, well, should it be Stephen Haggerty? Because that's my, sort of God-given name by my parents. And I don't think that's substantial enough to say that this isn't a objection we should consider. So I would move to deny the motion to dismiss.
Second.
Okay. So because we have two board members, which is quorum, we have two votes to move forward with the objection and discuss that.
Yes.
Okay, for the record, the motion to dismiss is denied by both Alderman Nguyen and Mayor Haggerty. So now we will go to the merits of the case, and for the board's consideration, this really comes down to a delineation of office. I know that the board has read the briefs, and forgive me, I'm switching between screens here, but for the board's consideration, I think it's important for the board to look at the Illinois Election Code 10 ILCS 5/10-4, which discusses the requirements for petition. It does state that all petitions for nomination under Article 10 for candidates for public office in the state shall, in addition to other requirements provided by law, be as follows. Such petitions shall consist of sheets of uniform size, and each sheet shall contain, above the space for signature, an appropriate heading, giving the information as to the name of the candidate or candidates in whose behalf such petition is signed, the office, the party, place of residence, and such other information or wording as required to make the same valid, and the heading of each sheet shall be the same. There has been case law cited by both parties with regard to whether listing, I don't think there's any material fact for the board that Ms. Carrillo lists the office as alderman. She does put her home address, which I believe is in the 8th ward, and that was testified to, and there was no testimony to the contrary that she does live in the 8th ward. So for the board's consideration, it's whether or not listing alderman on the petitions in her statement of candidacy and listing her home address really does meet, if it meets substantial compliance. There is some case law that was contained in the briefs. Ms. Carrillo, I believe, touched on a longstanding principle, and I'm going to quote Dean versus Smith. This is 2017 ILAP 1st 170404 at paragraph 22, which the court states the driving purpose of statutory interpretation is to ascertain and effectuate the intent of the legislature, which must be given its plain and ordinary meaning. Where the language is clear and unambiguous, a court may not depart from it by reading into the statute exceptions, limitations, or conditions that conflict with the clearly expressed legislative intent. Again, the question is whether the state statute that I cited is ambiguous or unambiguous. Is the term office in the state statute ambiguous or unambiguous? And again, there's a line of case law that states that certain language in statutes can be satisfied with substantial compliance, even a mandatory provision of the election code, and that's cited in Jackson Hicks versus East St. Louis Board of Election Commissioners, 2015, Bill 118929 at paragraph 36. There have been objections sustained to nominating papers, objection to nominating papers properly rejected, even though the candidate filed a statement of economic interest in the wrong county. And that's Samuelson versus Cook County Electoral Board. There's been single non-conforming page of petition that did not result in a disqualification of candidacy. That was Siegel versus Lake County Officers Electoral Board, 385 ILAP 3D 452. And so again, the case law really does state that substantial compliance can be effectuated where there is maybe perhaps not a clear meaning under the statute, that the terms are ambiguous. The terms are unambiguous. The case law seems to indicate that the candidates really must strictly comply. So the question I think for the board to really consider is whether Ms. Carrillo's nominating petition and statement of candidacy substantially complies with the statute, such that to avoid voter confusion, as she has mentioned. Mr. Finko obviously believes it does not. Ms. Carrillo makes her argument for the contrary.
So Ms. Kandersky, if listening to that, to me, what the standard, the term that we need to discuss is office, whether the term office is is clear and unambiguous. And could we ask Luke Stowe to ask everyone to turn off their video? Who's on the call? Okay, thank you. So I think that's the question. I mean, to me, that's the question is it unclear in the statute what a candidate needs to do in order to file the petitions? And here you described all of the various pieces of information that need to be on a petition, which include the candidate's name and the office and the several other items that you described. So to me, and the question is that clear from the state legislature? What is the office? Is that in agreement with what you're describing in terms of the standard that we apply?
Yes, I think that's really the first question for this board to consider.
Right, the necessity of having the word describing the office.
Correct.
So my thinking on this, to some extent, and I've spent a lot of time on this, is what's on the ballot. And although there are 9 aldermen in Evanston, alderman alone is not on the ballot. I mean, each residents vote for a particular alderman from the 2nd ward, alderman from the 4th ward. They don't vote for simply an alderman. And so to me, when I look at that, I think the office is actually alderman 1st ward, alderman 2nd ward. And you know, that's something that I've given a great deal of thought to in terms of what is the office.
Yeah, first of all, let me just say to Ms. Carrillo, I so appreciate you putting yourself out there and wanting to run for office.
Thank you.
I know it's not easy. I've had to go get the signatures. Alderman Nguyen has had to get the signatures and everything. I am worried about the ambiguity of, you know, just using a general term like alderman or like office. And I think, again, just when I ran 4 years ago, if I just said mayor, and it goes up to Cook County and they have to put it on the ballot because it's a Cook County clerk. Okay, well, what's he running the mayor of what, right? And so I had to say, well, I'm running for the mayor of Evanston. And I think it's really important for voters too, when we're going out with our petitions and asking them, you know, to sign and say, hey, we're running for, you know, I'm running for 8th ward alderman or 5th ward alderman or mayor or whatever, that the folks that are signing it, you know, see it on the petition. And so I, you know, I'm with Alderman Nguyen on this, and it really hurts. It really hurts because I know Evanston, and I know, you know, we pride ourselves on ballot access and wanting to have as many residents, you know, willing to run for office. But I do think in this case that this is a substantial error, that it wasn't indicated specifically what ward you're using. I did hear your argument about, hey, you know, Chicago in that one case that was cited, you know, it's 2.5 million people. There's a lot of people, 50 wards. But I think if you asked a lot of people here in Evanston, hey, what ward do you live in? Or there's a lot of people that wouldn't be able to tell you that. And so obviously when we're running for office, we need to know what ward we're running for. And we need to, you know, articulate that on the candidacy statement and on the petitions. And I feel like that's pretty substantial error if that's not done. So I am going to move to uphold the objection. Uphold the objectors.
Right.
Objection.
And before I second that, I also want to compliment you, Ms. Carrillo. I thought from your pleadings and also from the way you've spoken during these hearings that you are a lawyer. And if you're not, you certainly could you certainly are most of the way there. And
Thank you.
in terms of your research and your legal writing. So if you want a career to pursue, you've already got you're significantly down the path in terms of legal
Thank you.
reasoning. So,
Thank
and
you.
I too will join the mayor and second that. And I do appreciate the efforts that you have made.
Robin, I sent you this a while back.
Alderman Rainey, your mic is
You're not
on.
muted.
There we go.
Okay, very good. So that we have a motion to uphold the objection. We have a second by motions made by Mayor Haggerty, second by Alderman Nguyen. Could we do a short roll call vote?
We'll do a short roll call vote. Alderman Nguyen
Aye.
and Mayor Haggerty's an aye on that.
All
So
right.
2-0, we uphold the objectioners.
Okay, let the record reflect that the vote of the board is to uphold the objection. The candidate will be removed from the ballot. Ms. Carrillo, again, thank you. I know this is disappointing news. You did a wonderful presentation. Now procedurally for the board, what we have to do is either we have to recess shortly to complete an order to be handed out today, or the board would have to reconvene at a different date to distribute the order. So it's up to the board what we'd like to do today.
I think we should recess very shortly for an order to be prepared. And
All
then
right.
have that happen today rather than have us have to reconvene at another date.
Okay,
I'm okay. I agree with that. And Ms. Gandersky, can you make sure Ms. Carrillo knows what her appeal rights are and how that would work if she wanted to?
yes, Ms. Carrillo, you should consult an attorney for your appeal rights, but under the Illinois statutes, as you may know, you have 5 days once the order is issued to file an administrative review action in the Circuit Court of Cook County, okay?
Okay. Thank you very much to the board. I still plan on continuing my campaign, but thank you, everyone.
Good.
Thank you.
And thank you all as well. Thank you very much.
Okay, I believe we should do a short recess then to try to complete an order. Once we have a draft order, we can share our screen, Mayor Haggerty and Alderman Nguyen, to ensure that this is the order that you want to enter today. And then we can probably do an e-signature, and then we could email out the order to Mr. Finko and Ms. Carrillo today.
That sounds good. And I think it's smart that we're doing these today if we can, if it's not too complicated, and we resolve these cases today so that petitioners can get the clock going if they want to file an appeal.
Okay.
So how much of a recess would you like us to take?
Can we have 15 minutes?
Yes.
Certainly.
Okay.
Yes.
All right. Thank you.
Okay. Thank you.
Thank you.
Okay, once again, Kelly Gandersky for the City of Evanston's Law Department. Mayor Haggerty and Alderman Nguyen, we are ready to present you with the order, the draft order. If you are in agreement with the way that it is drafted, we will send it to the Law Department's assistant so that she can send it to you both via email for e-signature as soon as possible today. And then once you both sign, we can email it to Ms. Carrillo and Mr. Finko. Does that work for everybody?
Yes, that's fine.
Okay, great. Ms. Ruggie, will you please share your screen so that the board can review the order? Okay, and you may need to kind of scroll down and let them read it.
Yep, just let me know.
Could you scroll down a bit, Ms. Ruggie?
Yes. Oh, hang on.
Thank you.
Mhm.
I'm ready.
I'm
Mayor.
ready. I'm ready too. Keep the numbers. If you can keep like number 1. So I can see that. There we go. Okay, you can go down to number 4 if Alderman Wynn's ready.
Yes, I'm ready. Mhm.
Okay. If you want, I'm good to go down to applicable law.
Actually, may I raise a question? If you scroll back on factual findings, number 2. Oh, okay. We did not actually find that Nicole Mitchell Hall was a registered voter in the 8th ward.
It was conceded to. She's registered in the 5th ward.
Okay, so should that be changed to that?
It says is not. It says the word not. However,
Is not a reg-
petitioner is not registered voter in the 8th ward. So Tom Mosser is, and then the next phrase is Nicole Mitchell Hall is not.
Right, but she is a registered voter in the 5th ward.
Correct. You think that it should be stated that she is in the 5th ward?
We can change it.
Yes, I would prefer that
Maybe
it
you
be
just add,
changed.
maybe you just add then, just keep it is not registered in the 8th, because I think that's important. But is a, 5th, an Evanston 5th ward resident or something.
Registered voter.
Yeah, registered.
Thank you.
Can you see the changes?
Yes,
Yep.
thank you.
Okay, okay.
If you can scroll down now
Yeah.
to the applicable. I'm good when
I'm
Alderman
good too.
wins.
Yep.
I'm good when Alderman Wynn is.
Yes, I am as well. Thank you. I'm fine with that.
Okay,
Yes. I'm okay with that.
me too.
Okay.
If we could just have 2 minutes to contact our assistants so that this can get emailed for e-signature, and then we can get that to you, Alderman Nguyen, and to you, Mayor Haggerty, in just a few minutes.
Okay. Thank you.
Okay. So Kelly, it is the procedure on these electoral board opinions that all members of the board have to sign them. I forgot.
Yes. You should
Okay.
sign. Yes.
Yes,
All right, so you're
that's
gonna
what
do,
happened 4 years ago.
okay, so you're gonna do that, Kelly, via the system that we use internally with the system and the LIDA?
Yes. We're gonna do it right now.
Okay, great.
So we could just
All
have 2 more minutes and we'll be right back on.
Recess for a
Thank
couple
you.
minutes, get this back.
Okay, Mayor and Alderman Nguyen, Lolita is emailing it to you right now for your e-signature. So you should be receiving that shortly.
Okay, thank you. Kelly, do you need us to sign this before the board proceeds?
I think it would be most expeditious if we could do that, because I'd like to email this to Mr. Finko and Ms. Carrillo as soon as you're done signing.
Yes, okay.
Ms. Ganderski, as we move forward, do you think it's possible for the other cases to, well, since Alderman Nguyen will no longer be on the board, to just move forward? We hear a case, determine it, your team starts working on the paperwork, and maybe at the end for the rest of the cases, we'll come back and do all of this. I don't know if that was the plan already.
It'll be up to the board. I'd just like to keep in mind that that would keep a lot of attorneys and a lot of the parties waiting for the entire day to get their decision. So I'm not sure that that's, I'm not sure if that the board wants to consider in light of the parties waiting today. This is going to be a long day. You wanted to just do it case by case and get the orders out one at a time, but we'll have a few minutes to think about it.
Do the attorneys need to be, given the order before, they leave, or can we just email it to them?
If anyone leaves before the decision's rendered, we have to reconvene in another date. So we have to render the decision publicly, in other words.
Okay, and by rendering the decision, it has to be signed by us.
Yes, the order has to be signed and distributed today. So the same day. Yeah.
Okay, no problem. Thank you.
Okay, the order was signed. Miss Alexandra Ruggie will be emailing it out to Mr. Finko and Miss Carrillo right now. So Mr. Finko and Miss Carrillo, if you do not receive it in the next 10 minutes, please let us know. But you should be getting that shortly. Miss Ruggie, did you hear that?
Yes, I'm working on that now.
Thank you. All right, I think Mayor, we are ready to proceed whenever you and the other board members are.
Okay.
So I will be stepping off now. Our proceedings are completed. Is that correct, Ms. Kandorsky?
Yes, Alderman Nguyen, I believe that is all for you today.
Okay, thank you very much.
Thank you.
Thank you, Melissa. All right, let's see. Do we have Alderman Rainey with us?
I think I saw her drop off the call a bit ago.
All right, Kelly, can you text her and let her know?
She's here.
Okay,
She's here. Alderman Rainey, can you hear us? Okay, I think you're off mute. Okay, I think everybody's here.
All right, I don't see Alderman Rainey. Is she able to?
I'm here.
If you-
I'm here.
Okay.
I'm here.
Oh, let me go to.
I can't see you.
view. Oh, there you are. There you are. Okay, now I feel better. All right, we are now going.
Mayor, I can't see you.
Can't see me? Oh, that's strange.
Can
Okay.
anybody see the mayor?
If you
Yeah,
switch to
maybe
gallery view, go to gallery view.
That
I
was my
am.
problem. That was my problem. I wasn't on gallery view. That's why I couldn't see you. All right, it's 2020. We're all trying to figure out how to use Zoom still. We are going to continue with the board meeting. Now we have disposed of one case. So now we are going to move on to another case. Let me ask the board, do you have a strong preference on how you'd like to go through if we want to combine the Eric Young cases like we did last time? And again, both parties, Miles Davis.
Well, we didn't combine the cases last time, but we did hear the Eric Young case first. So I think keeping a similar order to to Monday's, not last week's, Monday's proceedings makes sense. So we went with the David Foster case first.
If everybody's fine with that. Ms. Kandorsky.
Excuse me, Mayor. David Foster here. Might I make a suggestion that I think will promote the efficiency of this process and make it easier for the board to deal with, and that is that the 003 case go first. That's Miles Davis, represented by Ed Mullen. The two cases overlap entirely on the binding issue, but I have some additional issues that I'd like to have time for. And so it seems to me what we ought to do is address the binding issue that's the sole issue raised by Mr. Davis, represented by Ed Mullen, and then move on. It's also the case that 003 is the earlier filed case, 006, which is the Catherine Whitcomb case, is the later filed case. So I would suggest and formally ask, if you'd like me to, that's the ordering the board takes.
May I
Okay.
briefly
Mr.
respond?
I would prefer to do the Catherine Whitcomb et al. Case first, because there are a
Okay,
number
so
of matters.
let's,
Mayor, may I
okay.
briefly respond?
So
just to
let's hear
Mr.
from
Foster's?
David Dale, and then I would like to hear the thoughts of our attorney, Kelly
So I
Gandersky.
was
Go
going
ahead,
to
Mr.
make,
Dale.
I was going to make a procedural motion of my own. I think it makes sense here to consolidate these two matters for a couple of reasons. Number one, as Mr. Foster pointed out, both objections share the issue of the binding argument. So the board could be facing potential res judicata issues if it were to hear these cases separately and come to different decisions based on this exact same issue. From a practical standpoint, I know this is going to be a very long day of hearings, and I'm prepared to address both objections in the same proceeding. In fact, I know I'm only limited to 10 minutes, and technically it's two cases. That would be 20 minutes. I would be willing to even just do it in 15 minutes from my side. So I'm offering up this opportunity to consolidate because I think it makes sense from a legal standpoint, and from a practical standpoint, I think everyone would be pleased by the consolidation.
Okay, thank you, Mr. Dale. Mr. Mullen, did you want to add anything to this before I ask Ms. Gandersky?
I had objected on Monday to the consolidation, mostly because I didn't want the record to be combined with Mr. Foster's second through fourth objections, which we did not make and don't necessarily agree with. But because Mr. Dale has filed a consolidated brief, and because I would prefer that the board not vote before having heard Mr. Davis's argument as well as the other objector's argument, at this point I would agree to consolidation.
Okay, thank you. And Ms. Gandersky, have you had some time to think about these two particular cases and how you think it may be best for the board to proceed?
Yes, I don't disagree that consolidation is probably the most efficient. I do agree with counsel that if the binding issue is dispositive, I mean, then the rest of the issues are moot at that point. So how I would do this is if you were going to consolidate the matter, I would hear the binding issue first, since that's the common issue amongst all the parties, and then proceed with any remaining issues, should any remaining issues remain.
So I agree with Mr. Mayor, Chairman. I'm fine with consolidating. I would rather deal with the non-dispositive or the other three objections, lines objection 2 through 4 first, for the sake of the public's edification. So I think it's important that we set board precedent. It's important that this board creates some precedent of our own on those matters, so we have cases that folks can look back to in the future on those particular matters. So I wouldn't like to see those matters just be made moot when the board hasn't ever in its history, or in the history that I know of, made a decision on those matters.
Alderman Rainey, do you prefer Clerk Reed's approach or the one proposed by Ms. Gandersky and sort of agreed to by the councils for these representatives, for these objectioners? Now I don't see Alderman.
I think
Rainey.
Alderman Rainey left from what I just saw up at the top there.
All right.
But just to clarify, I agree with everything that all the attorneys said. Just we can consolidate. I'm for that. Just dealing with the Catherine Whitcomb et al. Objections 2 through 4 before getting to the binding issue, just to create some case law and some precedent here on this board for those matters. So boards that come after us, it's very clear what they do when these situations come up.
All right, let's see if Alderman Rainey.
Mayor, I'd like to suggest, though, I mean, I'm happy to separate those out, but I do think that there's certainly a substantial probability or possibility that the binding issue does moot things. And once we have a determination on the binding issue, we can decide what else needs to be addressed. And so I think it will be more efficient, actually, to keep the cases in their order as filed 003 first and then 006.
Yeah. Are you supportive of a consolidation though? Of hearing these cases, but we go with the binding issue first, which is made in both cases. Okay.
Yes, that's correct, Mayor. That's exactly, I agree with the consolidation. I think it's an excellent idea. It will avoid a lot of duplicative record material. So I agree with that. I'm just suggesting a slightly different ordering.
Yep, I got it. Ms. Ganderski?
Yes, I just wanted to say that a court would, and I think council would agree with me, a court would always hear what could be the dispositive issue first, just for judicial efficiency. So, I understand Clerk Reed's point, it's well taken. However, in a court, they would always hear the issue that's common amongst the pleadings first, especially if it's dispositive, because again, it would render the rest of the issues moot, and it would not require the board to have to hear all of that.
Got it. Thank you. Alderman Rainey, I know we lost you and you're back, so it's good to have you back. Do you have I
was cut off. I was shut down.
Okay. All right. So what was presented by Ms. Ganderski and discussed by the attorneys is to consolidate these cases. So we'll hear them together, but we would hear the overlapping case first, which is the binding issue, and come to a conclusion on that. And if we don't uphold the objection, then we would hear from the Catherine Whitcomb versus Eric Young on their other arguments. And I think Clerk Reed was arguing that even if we reach a decision that, let's say the board agreed with the objectors on the binding issue, he's still saying we should address the other issues. Is that correct, Clerk Reed? The board should.
It's just to create a precedent. So in the future, if objections similar to the ones raised in the Catherine Whitcomb et al. Objection 2 through 4, if those come up in the future, a future board has the wisdom of this board to make a decision. And maybe quickly make a decision. So let's do the work now. So
I wouldn't want anybody. Gotcha. I wouldn't want anybody acting on my wisdom on something that sort of is moot. So I'm of the opinion that if this board were to agree with the objectors on the binding issue, that the case is handled for Young, and then we move on to the next case on our docket.
Certainly, if I can make one last point, Chicago has an index of electoral board decisions, which are super helpful for both folks who are preparing to run for office and folks who are objectors and the entire public, because you can see very clearly with their index of electoral board decisions what matters will get you on the ballot and will not get you. If you get your election date wrong, does that disqualify your entire petitions? I think it's important for this board to have a precedent here, so folks can easily understand what the rules are, what's worth filing an objection and what isn't worth filing an objection, and save folks time and money in the future, and have, like I said, a precedent that makes it clear what you have to do and what you don't have to do when you're filing for office.
Understand. I think differently on that, but I understand what you're saying. Again, if this board does not agree with the objectors on the first issue, we're going to hear all those other issues in Whitcomb versus Eric Young.
Okay, I think procedurally speaking, Mayor, so if there was an agreement to consolidate, was there a motion and a second by the board to allow that?
Make a motion to consolidate the Catherine Whitcomb et al. Case with the Miles Davis versus Young case.
I'll second that. Okay, so roll call vote on the motion to consolidate case number 20-MOEB-EV-03 along with case number 20 MOEB EV-06. I move the motion. Oh, wait, that's the motion. It's already been moved and seconded. Clerk. Yep. So Clerk Reed moved and seconded. How's your vote on that, Clerk Reed? Aye. Alderman Rainey
Aye.
and Mayor Haggerty's an aye on that. Okay, so on a 3-0 vote, we consolidate.
Okay, second procedural item is to hear the issue of the binding first as to both matters. And then we will hear the rest of the remaining objections. So I need a motion and a second and a vote on that.
I make a motion to hear the objections 2 through 4 first. I do think that's really important, so I'm going to at least make the motion for the record.
Is there a second? All right, there's no second to that motion. I'll make a motion that we hear the overlapping issue, which is the binding issue in both of these cases first, and then we can discuss as a board whether we at that point and do a separate motion if we want to hear the other issues. So my motion right now is to hear the binding issue raised by both parties.
Is there a second?
Second. No, we already.
All right, roll call vote, please.
Okay. All right. Clerk Reed?
Aye.
Alderman
Aye.
Rainey? And Mayor Haggerty's an aye. Okay, so on a 3-0 vote, we've are going to hear the binding issue first. So Ms. Gandersky, if you now can lead us in the procedures through this with the parties.
Yes, and keep in mind, everybody, there's a court reporter, so please speak and spell your names clearly when you're called. The first case, I want to go over all the pleadings, and then I will do the same with the second case, just to make sure that the board has received everything that was filed. This is case 2020 MOEB-EV-03 Miles Davis versus Eric Young. I have an attorney appearance on file from Ed Mullen representing Miles Davis, the objector. Mr. Mullen, please state and spell your name for the record.
Ed Mullen, M-U-L-L-E-N.
Okay, I have the appearance of counsel on file for David J. Dale, representing Eric Young. Mr. Dale, please state and spell your name for the record.
David Dale, D-A-L-E.
All right, and we have, in this case, the EV-03, the objector's petition that was filed by the objectors, and we have respondents Eric Young's combined response to petitioner's objections to candidacy papers filed by Mr. Davis. And that is all that I have in this docket. Is that correct, counsel?
Yes.
All right, very good.
My apologies, Ms. Gandersky.
Excuse me, there's one more pleading. I have objector's response to candidate's motion to dismiss. Mr. Mullen, is that correct?
Yeah,
You're on
that's
mute.
a response yesterday afternoon.
We have it. Okay. So the board should have that as well. Now going to the next case, 20 MOEB EV-06. We have petitioner objectors, Catherine Whitcomb et al. Who do we have for counsel for the petitioners?
We have David Foster here, Ms. Gandersky, D-A-V-I-D-F-O-S-T-E-R.
And again, we have Mr. Dale on behalf of Mr. Young. Is that correct?
That's correct.
Okay, and in this case, I have the original petition objecting to candidacy of papers. I have the appearance of counsel of David J. Dale. I have the respondent Eric Young's combined response to petitioner's objections to candidacy papers. And I have the reply to combined, excuse me, I have the combined to the reply response of Eric Young. Am I missing anything else?
Believe that's complete. I want to make sure that I'm clear on the determination that was made earlier this morning that we're going to include in the record here, obviously the original candidacy papers as filed with the clerk's office. Is that correct?
So everything that's been put on file with the clerk's office will be made part of the record today. And that was by stipulation in the last case, and that was by the agreement of the board in the last case. So I believe that'll be the agreement of the board in this case as well.
Very good. Thank you.
All right. Are there going to be any lay witnesses called before we begin, counsel, for objectors? Any lay witnesses to be called in your case in chief?
I would be calling the deputy clerk and Mr. Young.
Okay, is Deputy Clerk Gomez on, please?
Hi, Kelly, I'm on.
Okay, Deputy Clerk Gomez, you were sworn on Monday. You are still under oath. Do you understand that?
Yes.
Okay, and I'm sorry, Mr. Mullen, who are you also calling?
Pardon?
Who is your second witness?
Mr. Young.
Okay, Mr. Young, are you on?
Morning.
Mr. Young, I don't recall if I previously sworn you in, so I'm going to ask you that you raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, let the record reflect Mr. Young has been sworn. Mr. Gomez has been previously sworn. Can I ask counsels to stop sharing your screen right now
Sure.
until we're ready? Thank you. All right. So Mr. Mullen, Mr. Foster, do you have any lay witnesses to call?
No, Ms. Gandersky.
All right. Mr. Dale, do you have any lay witnesses to call?
Only the two that have been identified so far by Mr. Mullen.
All right. Any preliminary motions before we begin by any of the council? All right. Hearing none, I think to do this most expeditiously, I would like to give Mr. Mullen 10 minutes to present his case in chief on the issue of the binding. Mr. Foster, 10 minutes and your case in chief on just the issue of the binding. Mr. Dale, you'll have 10 minutes in response, or excuse me, 20 minutes in response on the issue of the binding. And then if there's rebuttal, we'll take rebuttal after that as it comes. Does that sound agreeable to all the parties? Yes. Okay. All right, Mr. Mullen, you have 10 minutes to begin your case.
Okay.
Ms. Riggin, please set the clock.
Sorry, I'd like to start by calling Mr. Gomez as a witness, and I'm going to share my screen now, if that's okay, with the first exhibit for Mr. Gomez. Do you see that or not?
Yes.
Okay, it seems to have disappeared off my screen. There we go. Okay, good morning, Mr. Gomez. You testified on Monday that you are the deputy clerk, correct?
Correct.
And you testified that you received the petitions from Mr. Young when he filed those with the city clerk in Evanston. Is that correct?
Correct.
Okay, and you also testified that you had a conversation with Mr. Young when he dropped those petitions off. Is that correct?
Correct.
Okay, and did you tell Mr. Young that filing the petitions without them being bound was legally sufficient? Okay.
Sorry, I didn't hear the answer.
No.
Okay.
Okay. So I have put up on the screen what has been attached to the objector's petition as Exhibit 1. Do you recognize this, Exhibit 1?
Yes.
And what is Exhibit 1?
That's the statement of candidacy.
And is that the statement of candidacy filed by Eric Young?
Yes.
And is that a photograph that you took of the statement of candidacy filed by Mr. Young?
Yes.
Okay, and is this the form that Mr. Young submitted his petitions to the Evanston City Clerk in?
Yes.
And I see on the left-hand side that there looks like there's a manila file folder. Were the papers enclosed in that file when they were handed to you?
Yes.
Okay, and does that file have any pockets or clasps in the file?
No.
And so the papers were placed loosely in the file folder. Is that what your testimony is?
Yes.
Okay, I have no further questions, and I think for efficiency purposes, it might make sense for Mr. Dale to take over the time now and cross-examine, but I'm certainly willing to let the board make that decision.
You're on mute.
Kelly.
Sorry. Mr. Dale, do you have any cross-examination based on that testimony?
I do. Does the board want to permit Mr. Foster to do a direct examination first? I'm just wondering if we're going to go direct cross and then a separate direct, separate cross. I'm not sure if that makes sense.
He did that on Monday.
Yeah,
Okay.
I'm satisfied with the testimony as it's come in on Monday plus today. So thank you.
Okay, so Mr. Foster's going to waive his questions for right now. Mr. Dale, you've got the floor.
Thank you very much. Mr. Gomez, you've testified twice now in this case that you were there on November 23rd when Mr. Young delivered his petitions. Is that correct?
Yes.
Can you, for the record, can you just briefly explain sort of physically where this handoff took place?
It took place here at the Evanston Civic Center downstairs in room G300.
And is that a room that's designated for the receipt of petitions ordinarily, or is that a room that was set up this year due to any kind of pandemic considerations?
It was set up this year due to the COVID-19 pandemic.
Okay, where would you ordinarily receive the petitions if we didn't have COVID-19 pandemic issues to deal with?
On the first floor in the clerk's office.
Okay. When Mr. Young arrived and tendered what you testified to was a manila folder to you, when you received the folder in your hands, did any of the papers fall out?
No.
Did they scatter onto the floor or onto the table? Did you have to pick them up?
No.
So they were secure in the folder and they were fastened together in that they didn't fall out of the folder.
Correct.
Okay. You also testified that you had a conversation with Mr. Young about binding or about stapling these. To the best of your knowledge, what do you remember that conversation was?
Objection, no foundation. That's a misstatement of his testimony.
I'm happy to withdraw the question and lay the foundation.
You could just lay some brief foundation.
Certainly. Mr. Gomez, you testified earlier that you had a conversation with Mr. Young on November 23rd. Is that correct?
Yes.
During that conversation, did Mr. Young ask you any questions about the binding of his documents?
No.
You don't recall Mr. Young asking you if the documents needed to be bound?
I don't recall, no.
Did Mr. Young ask you any questions about the form of his papers?
What do you mean by that?
Did Mr. Young ask you if the papers were in an adequate format, for example?
To be filed?
Yes.
Yes.
Okay. And what was your response to that question?
My response was that Mr. Young could file them however he chose to.
And your testimony today is that you said, however he chose to? Or are you paraphrasing? That's all I'm
paraphrasing.
Okay. When you took the manila folder from Mr. Young, what happens next?
I have them fill out a receipt that we give them as a copy that they submitted their paperwork. And then I take a picture of the filing so that way I can upload them to our Google Sheet.
And this picture that you're taking, is this done in the presence of the candidate, or do you take the folder to another room?
It's done right there in the room.
Okay. Once the candidate has turned in the folder, do the folders remain in the room, or what happens to them next?
They remain in the room with me until the end of the day.
Okay. Now, to take the photos, I presume you had to open the cover of the manila folder to take pictures of the petitions. Is that right?
Correct.
To the best of your knowledge, when you did that, did any of the papers fall out or become scattered?
To the best of my knowledge, no.
Now, with other petitioners who had bound or used a paper clip or had used a binder clip or any other way to collect the papers, do you ever remove those bindings, or do you take the photographs with the bindings still in place?
I take them with the binding still in place.
And are the documents at any point scanned or uploaded into a computer?
Yes.
And to scan the documents, do the bindings have to be removed?
Yes.
So presumably at the time that the petitions are handed to you, between that time and the uploading, the documents are unbound at some point.
Yes.
During this process of receiving the documents, and I'll limit my question to Mr. Young's petition in particular. During the process of receiving the documents, photographing them, and then having them uploaded, is anyone else involved in this process or observing the process, or is this done entirely by you?
It's done by me.
So there is no other person who could verify whether or not the documents became unbound, unsecure, or unfastened, or became loose. Is that correct?
Correct.
I'm going to object to that question. I believe that misstates the prior testimony and calls for a legal conclusion about whether they were bound or fastened.
Your objection's noted for the record.
I have no further questions.
All right, thank you, Mr. Dale. Mr. Mullen and then Mr. Foster, any redirect for Mr. Gomez after that cross-examination?
No.
Mr. Foster, any questions?
Mr. Gomez, good morning. Mr. Dale was just asking you about the scanning process, and I believe you testified that you do need to take apart the bound documents to scan them. After you do the scanning, do you re-bind the documents?
Yes.
So you return them to their original bound form, however they were submitted. Is that correct?
Correct.
Thank you.
Okay, any further questions for this witness? All right, seeing none, Mr. Mullen, I believe you still have some time left based upon cutting it short. So do you want to, anything else you want to add?
I hope so. I think I only took a minute or two with him, but I'd like to call Mr. Young now.
All right, Mr. Young, you've been sworn. Mr. Mullen, Mr. Young is your witness.
Oh, I see you now.
Morning.
Good morning. Mr. Young, you filed petitions to be a candidate in Evanston with the city clerk, correct?
Correct.
And how did you find the form of the statement of candidacy?
Where did I find it? I think it was sent to me by another candidate.
Okay. Did you ever look at the candidate guide that was published by the State Board of Elections?
I remember glancing over it, yes.
Okay. And did you note that that State Board of Elections guide advised you to seek legal counsel?
No, I don't recall it.
Okay. And did you note that the guide said that the petitions needed to be bound when they were submitted?
I did notice that.
Okay. So you were aware when you went to file your petitions that they were supposed to be bound?
Correct.
Okay. And in the process of being a candidate, have you heard stories about candidates being kicked off the ballot for technicalities?
No, I've heard about challenges, but I do not know any direct stories.
Okay. So I'm going to share with you the exhibit that Mr. Deputy Clerk Gomez authenticated earlier. This is your statement of candidacy, correct?
Correct.
And you see at the top of the statement of candidacy that it says attached to the petition?
Correct.
Okay. And then I'm going to show you another exhibit, just a moment.
And for, just so the court reporter can keep up, Mr. Mullen, what are you calling this, Exhibit 1 or Exhibit A?
The one that was shown earlier is Exhibit 1 to the objector's petition, which is already an exhibit to the record. And then this document here is also in the record as one of the petitions of Mr. Young. And this is one of the petitions you filed, Mr. Young, correct?
Correct.
And you see at the top that it says bind here?
Correct.
Okay. So when you had
Okay, Mr. Mullen, I'm sorry, we need to identify this for the record if we're going to have a clear record. So state what this exhibit is.
This exhibit is a page of the petitions that were submitted by Mr. Young that have already been entered as an exhibit as part of his petition papers. This is sheet number 1 of the nomination papers filed by Mr. Young.
Okay, and I'm just going to note for the record, it says consolidated primary petition at the top of the document. Okay, go ahead.
So when you brought your petitions to the Evanston City Clerk, you brought them to the clerk's office unbound, is that correct?
Correct.
And did you have a conversation with the deputy clerk as to the form that the petitions needed to be submitted in?
Yes.
And what did you ask the deputy clerk?
I asked him if it was sufficient, turning him in the way I did.
Okay. Did you specifically ask him whether it was sufficient to turn them in without them being stapled or having some other fastener?
Yes.
Okay. And what did the deputy clerk say to you?
He said, "This is okay. I'm just going to go make copies." At which point he left the room with my folder.
Okay. And when he told you that, you understood that the law required them to be bound. When you walked into the office, you understood that.
I think I was not sure.
Okay. You testified earlier that you knew they were supposed to be bound, correct?
Yes.
Okay. I have no further questions.
All right, Mr. Foster, I'm sorry, Mr. Dale, any, well, let's do it this way. Mr. Foster, any questions following Mr. Mullen? And then we'll turn it back over to Mr. Dale.
Yeah, just briefly, Mr. Young, good morning.
Morning.
Did you ask Mr. Gomez whether he had the express authority to bind the city with his statements to you there at the clerk's desk?
No.
And did he ever say anything that to the effect that he had the express authority to bind the city of Evanston by his statements at the clerk's desk?
No.
Thank you. No other questions.
All right, Mr. Dale, any redirect?
Sure. Mr. Young, do you know what express authority even means in the legal sense?
No, I do not.
Okay, so do you go around when you have dealings with city representatives asking them if they have the express authority to do the things that they're doing? Like you go to the DMV, do you ask the window, do you have the express authority to process my papers to renew my license?
No, I do not.
Okay. Mr. Mullen asked you a question about a candidate's guide. Do you remember in the guide, did it explain in detail how you were supposed to bind the papers? For example, did it say you will use a staple of sufficient size or you will use a fastener of sufficient size? Do you remember any of that?
No, I do not.
So you don't remember any specific directions in the guide about how the papers would be bound?
Correct.
I believe Mr. Mullen showed you his second exhibit and he had pointed out at the top, there was a statement that said bind here. Do you recall that exhibit that he showed you?
Yes.
Now, on that same exhibit, there was a space for voters to sign and enter their addresses. Do you recall that?
Yes.
Now, did you understand that it wasn't for you to fill out the section where it says voters sign and add addresses here?
Yes.
Right. And then underneath it, there was a notary section. And did you understand that that section wasn't intended for you to fill out as a notary? Do you understand that? Did you understand that?
Yes.
So is it possible when you saw the binding at the top, the binding instructions at the top, you may have thought that that was an administrative task or something that would be accomplished by someone other than you?
Yes.
I'm going to object that that was leading and counsel was testifying for the witness.
This is cross-examination, so I'm allowed to lead the witness.
Your objection, hold on. We're not talking over each other. Okay. Your objection's noted for the record. Mr. Dale, please proceed.
Mr. Young, in your opinion, can you recall your conversation with Mr. Gomez? What did you exactly say to him, and what was his response to you?
I said, I presented with a folder. I said, is this sufficient? Do I need to do anything else? Do they need to be attached? He said, no, this is fine. At which point he left the room with the folder. No, I'm sorry. No, this is fine. I'm going to go make copies. At which point he left the room with the folder.
So based on the totality of the circumstances as you've testified to them today, specifically your tendering of the documents in a manila folder, the fact that they didn't fall out or scatter on the floor, and the fact that Mr. Gomez, when you prompted him, told you that they were in an acceptable format, did you believe that you had complied with the requirements for binding your petition?
Yes.
I'll post the same objection to that question.
Objections noted. Mr. Young, please answer the question.
Yes.
Thank you. No further questions from me.
All right, Mr. Mullen, you've got redirect based only on that. It's redirect for you based only on that last testimony, and Mr. Foster, both of you will be able to do that. Mr. Mullen first, and please note that we'll do about 2 minutes.
Okay, I have no further questions.
Mr. Foster.
Questions either. No further questions, Ms. Gandersky.
Okay, no more questions for Mr. Young. Mr. Mullen, any further arguments before we end your case in chief? And Mr. Foster, you'll be asked the same. Mr. Dale, you'll have plenty of time to respond.
Okay, how much time do I have?
I have you having about 5 minutes left.
Okay. I do have some additional argument. So it is undisputed, I think, that the candidate is supposed to submit his papers for nomination in a way that is securely fastened in book form. It is also clear that there is an Illinois First District Appeal opinion saying that is a mandatory provision of the election code, which means that if the candidate fails to satisfy that provision, the candidate has submitted invalid nomination papers and his name should be stricken from the ballot for the election that he seeks. The first question is whether the candidate here complied with the provision that his petitions be submitted in a way that were securely fastened in book form. And we submit that he is not. We have cited some case law in the brief that I'm not going to repeat, but I think the question is pretty clear that there was nothing that was holding the papers together, and there was nothing that was fastening the papers to the file folder. And whether Mr. Dale believes it's valid or not, the Illinois Appellate Court has held in multiple districts and in multiple cases that the purpose of this is to make sure that the papers cannot be pulled apart and cannot be tampered with. And it's clear from the way that they were submitted that there was nothing holding page 1 to page 2. There was nothing holding page 2 to page 3. There was nothing holding page 4 to page 5. So they were not securely fastened to one another. The word fasten is used a lot in the English language. You think about fastening your seatbelts. You think about fastening the back of a dress. Imagine those things and then look at Mr. Young's petitions, and I don't think you can reasonably believe that is a fastened seatbelt that would make you feel secure. So I think the first question of whether this is securely fastened, I believe the board needs to find that it was not. The second question is the issue of COVID. And frankly, The Illinois Election Code does not give this board the authority to relax any of the provisions of the code. Now, the circuit court and the appellate court and federal court might have that authority, but this board's authority is limited to just applying the law. And I would submit that Mr. Young was aware that his petitions needed to be bound before he came to the office. I don't think he could rely on the office having the materials that he needed to bind his own petitions. And there's really no excuse for him not to have done that before he came to the board. And I certainly don't think COVID is the excuse. And I don't think this board would have the right to relax a mandatory provision of the election code on that basis. And the final question relates to whether Mr. Young's reliance on the clerk was reasonable or unreasonable, and whether that saves his nomination papers. I think there's some dispute on the record as to exactly what the deputy clerk said to Mr. Young, but I think ultimately it does not matter because the deputy clerk does not have the authority to bind the city. Imagine if the deputy clerk had said, oh, you only need 25 signatures. Or if the deputy clerk had said, you don't need to sign the statement of candidacy. Or if the deputy clerk had said, you don't have to file your receipt for statement of economic interest, you can just file your original. This board would not allow what the deputy clerk said to a candidate to change a mandatory requirement of the Illinois Election Code. And the case law that I cited in my brief makes one important distinction between cases where reliance has been allowed and where it hasn't. And that distinction is whether or not the person who was talking to the clerk actually knew what the law required. And here, Mr. Young has admitted that he was required to bind the petitions, and he knew he was required to bind the petitions. And therefore, under the case law cited in my brief, his reliance on the deputy clerk was unreasonable because he knew the law was otherwise. So the clerk does not have the ability to bind the city to an interpretation of the election law that is simply incorrect. And Mr. Young's reliance on what the clerk said is not reasonable because he knew that they were supposed to be bound. So I believe that this board under binding Illinois law is required to grant the objection and strike Mr. Young's name from the ballot. Thank you.
Okay, thank you, Mr. Mullen. I'm going to give Mr. Foster just 5 minutes, if you can, to argue any further points, and then I'm going to give Mr. Dale plenty of time to respond. You're on mute, Mr. Foster.
Sorry.
I'm sorry. I joined, first of all, in everything that Mr. Mullen has so ably stated. Second of all, I would suggest that the board focus on the various Court of Appeals cases that reject efforts to file even paperclip cases. There is the one that we've discussed a lot that had a particularly secure paperclip that kept the papers from being pulled apart. There's no such thing here. I think perhaps the closest case is the one that has been cited from the Chicago Electoral Board. It's Valentine, and it's attached to my paper. I'd suggest that the board take a look at that if it needs further assistance on this point. That the papers there were filed loose in a green 3-sided accordion folder. And so it's certainly a more secure version of a folder than what's involved here, and that was rejected. The Chicago board is obviously not controlling precedent, but it's a highly expert body that issues a number of these decisions every year. And so it's certainly useful precedent. As to the COVID-19 argument and the detrimental reliance argument, I join in everything that Mr. Mullen has said. I think it's clear that the unambiguous terms of the statute, section 10-4, require securely binding the papers together. It's undisputed that didn't happen here. The candidacy papers need to be rejected. Thank you.
Okay, very good. Mr. Dale, I'm going to give you up to 20 minutes if you want to respond to all of these arguments. So you have the floor for the next 20 minutes.
Thank you, counsel. I'm going to try to do it in 12 and save everybody the extra 8 minutes since I know this has been lengthy. First of all, good morning. Thank you, Mayor Haggerty, City Clerk Reed, Alderman Rainey, for the opportunity to appear on behalf of Mr. Young today and to support his petition to be placed on the ballot for 3rd Ward Alderman. Before I kick off my comments, I do want to have a running theme through my argument, and Mr. Foster did it for me. He claimed that the statute was unambiguous and that the terms and requirements of the statute were unambiguous. I think you're going to see pretty quickly here as we look at these actual cases that that is one of the most furthest from the truth statements about this statute. It is anything but settled. It is absolutely ambiguous. But of course, my time is really limited. I want to hope that the board will afford me the reasonable time necessary to address and rebut the objections to Mr. Young's petitions. But first and foremost, I want to note for the record today that there are over 100 individuals in the Zoom meeting today. I think we had about 60 or so participants at Monday's hearing. So honestly, first, I want to say I'm thrilled that so many fellow Evanston residents and constituents have turned out to observe the electoral process. I hope that for those who are possibly observing this for the first time, that their faith in the process is rewarded and that they leave today's meeting with a feeling that justice was done and the result was fair. So before I address the binding objection, I do want to note that Mr. Foster already voluntarily withdrew a number of his other objections, and I applaud and appreciate that decision. However, I think it does sort of lend credence in my own mind that maybe they weren't filed in good faith to begin with. But nonetheless, they've been withdrawn and we'll deal with those if we need to deal with them. So my argument today is going to be limited to just the one major issue, the issue of binding. So right off the bat, I think it's really important that we remind the board and the people who are listening that the burden today rests entirely on the objectors. Under the law, Mr. Young's petitions are considered valid, and it's the objector's burden to come forward and provide evidence refuting that validity. So if we move back to the issue of binding, in fact, I want to get away from calling it binding at all, because the election law statute itself actually never uses the word binding. What the statute says is that the petition sheets shall be filed fastened together in book form by placing the sheets in a pile and fastening them together at one edge in a secure and suitable manner. And that's really all we get from the statute. It actually gives us one example of what not to do. It says the sheets shall not be fastened by pasting them together end to end so as to form a continuous strip or roll. So other than a pasty roll of documents, the statute doesn't preclude any specific formats. It doesn't say you can't put them in a folder, or you can't put them in a binder, or you can't use a paper clip. We're only told basically that they should be in book form. And this is where we really run into the problem here. And it's a problem that actually the Objectors Council have done a better job than I did of pointing out. There's actually numerous courts throughout Illinois who have taken a shot at interpreting this specific part of the statute. And not only do they all admit it has to be a case-by-case fact-specific analysis, they have all come up with different results. For example, in the Bedell case, the court said, okay, paperclip is good enough. However, in the Guzman case cited by the objectors, the court says, actually, paperclip, maybe not good enough. And both of those cases are relatively good law. But I do need to pause here to make a legal point regarding those cases that the objectors cite repeatedly. First of all, Mr. Mullen cites the Guzman case, but as he admits in a footnote, it's an unpublished decision. And us attorneys know that in Illinois Supreme Court Rule 23 plainly states that those cases, those unpublished decisions, can absolutely not be cited for precedential value, even in this arena. Meanwhile, Mr. Foster has relied on a case, Giroux, and from that, he claims it was an appellate court case, and he claims that that case is directly on point. But in fact, the Illinois Supreme Court later reversed that case entirely and specifically pointed out that the argument about fastening was rendered moot because of the reversal of the entire case on previous grounds. It also has no precedential value for this board's decision. And finally, both counsel have also cited a finding and a decision from a 2015 Chicago Electoral Board hearing. But I would hope, as Mr. Foster pointed out, that the board and certainly City Council would readily understand that another city's electoral board's finding has zero precedential value in this proceeding. Now, again, I hate wasting what little time that I'm allotted addressing these legal issues that I felt, experienced legal counsel should have known from the outset. but I think it does sort of speak to the lengths that they're willing to go to try to remove Mr. Young from the ballot. But let's say even if we were to include the decisions from these cases, the results by my tally are paperclip good, paperclip bad, paperclip good, except if papers fall out, and then another vote for paperclip bad. So at the end of the day, honestly, there is no set rule here. The courts at the appellate level and even the Supreme Court have taken a shot at this issue, and every time we get a different answer. But here's where the board can step in and take a practical approach. This quote unquote binding requirement, it is mandatory. I will agree to that. But as both Mr. Mullen and Mr. Foster's own cases have pointed out, mandatory doesn't have the same meaning as strict. In fact, both the Giroux and the Jacostas cases that they cited agree that the standard of review is substantial compliance with the statute. The Giroux case put it best. It held that courts have found substantial compliance where a candidate attempted to follow the requirements of the statute, but inadvertently failed to meet them fully. So I have here a book. I think we can all agree that this book is in book form. It's a collection of papers. It's fastened along one edge. And we could presume that Mr. Young, had he felt passionate about his petitions, he could have gone and had them bound in book form. And we'd agree he'd be in substantial compliance. And it seems to tick all the boxes. But even books can have papers that are loose and unsecured. I've got here a stack of papers that are bound by a binding clip, but with just the simplest of presses, those two seem to fail to meet the requirements of a secure document in a book form. However, courts have found that these are adequate to meet the statute. We've all had a stack of papers that have been stapled together and a page has come loose. We've all had hole punch papers where a paper gives way because the hole punch becomes loose. I agree with opposing counsel that this rule is all about maintaining electoral integrity, and it's all about substantial compliance. So let's look at what Mr. Young did here. He collected his papers. He put them into a book form. He stacked them on top of each other. He even has a cover and a back jacket. He fastened them along one edge using the manila holders bind along the side. Then he brought them to the deputy clerk and he asked the deputy clerk point blank, "Is this good enough? Do I need to staple them as well?" And the clerk said, "No, these are fine as is." And this wasn't the only case in which the deputy clerk testified that he had similar conversations along these lines. And why did the deputy clerk say that? Because as he testified, he's leaving the room anyway with the documents and immediately unbinding them himself in order to scan them and enter them. So speaking of electoral integrity, how exactly is this requirement actually protecting the integrity of the process? Even had Mr. Young bound his papers with a clip or a binder or a stapler or put them in a book or whatever, the minute they leave his hands, they're immediately unbound in another room outside of his view. And as Mr. Gomez testified, no one else is observing this process. Nobody else knows if papers are falling out or becoming loose. No one else can certify or testify that these are being put back together the way they were found. So again, exactly what electoral integrity are we protecting here? Ultimately, the board is tasked with applying the law. I agree with counsel on this point. It can't rewrite it. It can't choose not to apply it, no matter how confusing or absurd it is. But if the question here is, did Mr. Young substantially comply? Did he do his best to provide petitions that were securely fastened based on his conversations with the deputy clerk? Then the board can absolutely fulfill its role here. It can apply the law. It can apply the myriad of decisions from these different courts, and it can say, yes, Mr. Young substantially complied with this requirement. In fact, earlier this morning, the board was able to determine that a nickname satisfied the full name requirement for a valid objection, even though the law doesn't say anything about nicknames. It was able to come to that determination, though, and apply the law. Here, the board can make the same determination regarding substantial compliance without having to rewrite or disregard the election law. At the end of the day, Mr. Young collected 161 signatures in the middle of a pandemic. People came out in cold weather, they came out masked up, they took precautions, and they signed his petitions because they support his cause. It should bother all of us, incumbents and candidates alike, that all of those efforts, Mr. Young's valid attempts to be placed on the third ward ballot, could be dashed over an argument over a single paperclip. But thankfully, the board has the evidence it needs to overrule these objections. It doesn't have to make a decision based on practicalities or common sense as much as I wish it could. The board can adequately find that Mr. Young substantially complied with the election law code and should confirm his spot on the third board ballot. Thanks. I reserve any remaining time for any sort of rebuttal that may be needed.
Great, thank you, Mr. Dale. Mr. Mullen, you have 2 minutes in response. Mr. Foster, you have 2 minutes thereafter, and then Mr. Dale, you'd have 4 minutes after Mr. Foster. So Mr. Mullen, any response in 2 minutes?
Yes, thank you. So Mr. Dale says that petitions are considered valid if not objected to. That's not entirely correct. Petitions are considered valid if they pass apparent conformity. And if you look at the Cook County Clerk's website, apparent conformity includes whether or not the petitions were securely fastened. So if Mr. Young had filed his petitions with the Cook County Clerk, we would not be here because they would have failed apparent conformity of the Cook County Clerk, which is the election authority that Evanston works with, and we would not have had to even object to it. Mr. Young's argument focuses very much on the phrase book form, but the reality is that he leaves out the rest of the sentence, which says, before being filed shall be neatly fastened, and fastened is the key word here, into book form, not just put in book form, but fastened into book form, by placing the sheets in a pile and fastening them together at one edge in a secure and suitable manner. So while the objectors or the candidate's argument focuses on book form, he's left out all of the rest of that. And the last thing I would like to say is that counsel repeatedly says this is judged by substantial compliance. It is not. Bendel, which is the First District Appellate Court opinion that governs this case, says, quote, inasmuch as Section 10-4 is mandatory, compliance with its provisions must be strict rather than substantial. And that is a quote from Bendel. I don't see the page number on here, but it's a direct quote that I just read you from the Bendel case, which says that it's strict, not substantial compliance that applies to this provision. And that's the First District Court of Appeal opinion that is binding on this electoral board. So I think under those standards, Mr. Young admittedly failed to meet those standards because his counsel is arguing that he substantially complied, not that he strictly complied.
All right, thanks, Mr. Mullen. Your time is up. Mr. Foster, you have 2 minutes.
Thank you. The standard here is whether or not it's securely fastened. And the cases that Mr. Dale talks about, yes, there is that one that decides there's a type of paper clip that was sufficiently secure to be securely fastened. But here, it's undisputed, there's no clip. There is nothing that is securely fastening the pages one to another. There was no effort at all here to fasten the pages together. Number two, counsel, Mr. Dale rightly points out that Giroux's appellate opinion was reversed in the Supreme Court on a preliminary ground. The issue there is that the clerk ended up testifying, and the question was whether or not it was prima facie improper for the clerk, who was also testifying, to be involved in the decision of the case. The Supreme Court effectively said that case automatically has to be reversed solely on the preliminary grounds. The other reasoning and analysis of the Court of Appeals still stands. Finally, Mr. Dale talks about electoral integrity and points out that the pages had to be, of all the petitions, have to be unbound when they're put through the scanner. But Mr. Gomez also testifies that as soon as they're put through the scanner, they are rebound in their originally submitted form. So we have clearly a binding here that continues to be protective and protect the electoral integrity. Thank you.
Okay, very good. Mr. Dale, you have 4 minutes.
Thank you very much, counsel. I do want to point out an inaccuracy in Mr. Mullins' reply, and I want to make this clear for the record. I am arguing both strict compliance and substantial compliance. Mr. Mullin is trying to limit my argument to just that of substantial, and that's simply not the case. I firmly believe, and I argue, and Mr. Young does too, that he did strictly comply with the requirements of the statute when he produced documents in a book form that were secure and fastened. However, I do think the substantial compliance standard of review is applicable here. Mr. Mullin repeats again that this is a strict compliance, but courts have interpreted that to mean mandatory and strict are two different things. You can have a mandatory requirement, but it doesn't necessarily have to be strict to the letter of the law. And that's pointed out in their own case law. Now, when it comes to this repeated issue of whether or not these documents were fastened, I think the operative word in the statute is, are they secure? Again, objectors keep saying this is all about election integrity. Let's preserve integrity. Let's make sure these documents aren't loosey-goosey falling all over the place and scattering when who knows what might happen to them. We heard testimony from the only two people who handled these documents, and both of those people, Mr. Young and Mr. Gomez, testified unequivocally that these documents were tendered securely. They never became loose. They never left the order that they were stacked in. And as Mr. Foster pointed out, they were put back into the same order. Mr. Young is in compliance with the statute in that he has tendered book form documents securely fastened, and they weren't loose. They weren't susceptible to the sort of fraud or any kind of tampering that seems to be what the statute is trying to prohibit. And again, just briefly, Mr. Foster keeps trying to bring up this case that was reversed and remanded. Mr. Foster knows that when a case is reversed and remanded for an entirely new hearing based on a procedural ground, then all of the testimony that followed is not good law. There will be a new hearing with new testimony. So to continue to try to cite this case as though it has precedential value here is just an attempt to mislead the council. At the end of the day, I rest on our arguments. Mr. Young has done what he needed to do, whether this board decides to apply a strict compliance standard or whether it also wants to apply the substantial compliance standard, and realize that Mr. Young did what he needed to do. He took the advice of the deputy clerk and he provided the documents in compliance with the statute. Thank you.
Okay, thank you, counsel, very much for your robust and prepared arguments. The question now goes to the board for a decision on the issue of whether or not Mr. Young's petitions were properly fastened such that he should either remain or not remain on the ballot.
Clerk Reed has a question. You're muted.
Oh, I'm sorry. Yeah, I didn't realize I was muted. Thank you, Mayor Haggerty. I was going to say first, I think we should deal with the motion to dismiss because there is a motion, a duly filed motion to dismiss the objections in their entirety.
I didn't notice that a motion to dismiss. I noticed the response said it was a response to motion.
I'm sorry. Yes. Yes.
I don't think there was ever a motion made.
Well, I do see that it says that the objector, and one of them in the Mullen case, it says that the objector's address isn't properly listed. That to me seems like a motion to it warrants a motion to dismiss. This is a item. Sorry. V. Yeah, V on the The Mullen objection does not provide an accurate address of the objector. That, along with a number of other things, the COVID or the pandemic, those seem like motions to dismiss. Am I wrong, Mr. Dale?
Mr. Dale, this wasn't fashioned as a motion to dismiss, but is that what you're making?
Council's right. I didn't style it as a motion to dismiss, but if the board wants to entertain the argument as a motion to dismiss, I would defer to my opposing counsel. I certainly didn't style it that way. I styled it as a combined response with the assumption that the burden of proof was on the objectors, and thus my response was limited to challenging whether they'd met that burden. But to Mr. Reed's point, since my particular response with regard to the objector's address being required on their petition, that does raise a question of standing, I suppose, and that could be subject to a motion to dismiss. I don't know if we want to just limit a motion to dismiss argument on just that argument alone and reserve the rest as just a response on my behalf. I guess my long-winded answer is I'll defer to whatever the board prefers.
Kelly, my thought is if this wasn't put forward clearly as a motion to dismiss and the other council didn't have the opportunity to respond to it, I wouldn't recognize it as such.
I'm inclined to agree with you, Mayor.
All right, so we're not going to open up for board discussion. Kelly, I do have a question. Is this like city council where I have to have a motion in a second before we can have a discussion? Or because this is a hearing, can we just go into discussion?
You can go right into discussion because the motion and the second and the vote was already made to decide this issue and to hear evidence first. So evidence is now closed. I think the board is open to freely discuss, and I'm here to assist if the board has any questions on the law.
Yes. Okay.
Can I just ask another question?
Yeah, and I want to, if the board has questions of council directly, I think that's okay as well.
Yeah.
Oh, that's what I was going to ask. And what if the board has questions of either of the witnesses?
I think the board should ask all the questions it has for council or their witnesses.
Okay, got it. All right, Clerk Reed, did you have something?
Yeah, certainly. So I think when we, well, since, we're not going to look at the standing issue, I think the first issue to maybe deal with is to strike off my list here is the, there's an argument about the pandemic and maybe the requirements being eased due to the pandemic. And what I've seen is that there are a number of cases, the Green Party and third parties filed lawsuits prior to filing that eased signature requirements, and the courts granted that. I do think that, after the fact, to raise the issue of the pandemic as a reason for not binding may not be proper here. I think that's, if you want to ease the requirements, you do that before the issue took place. I'm sorry, Dale, I'm getting your name confused. Your last name is it Dale, your last name, or?
It's happened for 39 years straight. So first name David, last name Dale.
Yeah, Dale. Okay, David Dale. Yeah, Mr. Dale. Okay. Can I ask you why Mr. Attorney Mullen made the point that this board has no authority to make a judgment based on the pandemic. Do you agree with that assessment? Do you think the board has the authority to relax the electoral rules due to the COVID-19 pandemic, specifically a rule about binding?
Sure. I don't think that the board has the authority to change the law or to apply or not apply it, or to apply it in a way it's not meant to apply it. I certainly agree there. It's not the board's purview to try to rewrite the law. That's the legislation's job. However, I think when we're talking about the idea of compliance and we're thinking about what was done in an attempt to comply with this, the issue of the pandemic, which is playing out in courts nonstop, we're seeing just all kinds of changes that are made in things that have been done the same way for decades now. We're seeing changes all over the board. And I cited that in some of my Northern District of Illinois cases. And you're right, they applied to voter signature requirements, but it just goes to show that even in the race for governor, the state is willing to acknowledge that changes need to be relaxed. I tried to elicit from Mr. Gomez that the process itself is different this year, where the petitions are dropped off, where the petitions are submitted, how they're handled. The city has unilaterally changed that. So I think that the city would be remiss if it didn't admit that plenty of procedures have been changed. The Open Meetings Act, the way that these hearings are conducted. So I do think while the board, and I'm sorry, I'll sum up my answer. While I do think the board is bound by the law and it can't change it, COVID and the pandemic are certainly considerations that should be factored into whether or not Mr. Young has complied.
All right, thank you. And just as to the office being moved, it was to create a more socially distanced, and I don't think that changes the law. We're still the clerk's office. Wherever we designate the clerk's office to be in the building is the clerk's office. To the next question I have, non-conform or apparent conformity. Mr. Mullen, you raised the issue of apparent conformity. And my office has, the clerk's office has taken the stance that we do not, we left it up to the board. I mean, the county, we're aware that the county clerk's office and other jurisdictions unilaterally make the decision as to whether petitions are in apparent conformity. First, Attorney Dale, are you familiar with the apparent conformity statute and that other jurisdictions do unilaterally invalidate petitions for, not apparently conforming with the statute?
I'm unfamiliar, but I will say I'm a little bit concerned here that if the city clerk's office, which is serving as both a witness in this case and also an adjudicator on the board, is going to start arguing points of law, I think we're going to start running into a conflict of interest here. So I want to put that at the outset. If this is going to be an argument of law between the city clerk and myself, then this is going to raise a serious conflict of interest, since the city clerk's office is also a witness to this case and serving as both witness and adjudicator. So that being said, no, I'm not familiar with this apparent authority that you're referring to.
Apparent conformity. Ms. Gandersky, are you familiar with apparent conformity as practices of other jurisdictions?
Yes, I think the standard here, though, it's really discussed in this particular issue is, and the courts have ruled on this, it's really substantial compliance. I do agree, I think all counsel agree that there is mandatory language in the statute, but what the courts have ruled on is whether that these specific instances substantially comply with that mandatory language, if that makes sense to the board.
Certainly,
so I really think the issue needs to be focused on that particular area of law and that standard.
Certainly. I'm just trying to work my way through to get to the substantive stuff. And, I just wanted to raise the issue of apparent conformity, that the clerk's office and myself did not issue any apparent conformity arguments for anyone's petitions. And certainly I will also note for Attorney Dale that the deputy clerk is not under the direction of the city clerk. The deputy clerk, in fact, is under the direction of the city manager's office. So there is some separation there.
Thank you.
I do want to, to that point with the deputy clerk, that's another issue. I think when we talk about the deputy clerk creating a binding, binding the city, as was raised by Mr. Foster and others, I think that the legal term for that is estoppel. Am I correct, Ms. Gandersky or any of the attorneys? Just the estoppel would be the, okay. And so does the deputy clerk, given that the deputy clerk, it does appear in a number of instances, well, first I'd like to maybe ask the deputy clerk a question, if Mr. Gomez is here.
I'm here, Clerk Reed.
Thank you, Deputy Clerk Gomez. Deputy Clerk Gomez, I do understand that you are currently at the direction of the city manager's office, but did I offer a suggestion that you not give advice to any candidate?
Yes.
Is that correct? Okay. So it is correct that the clerk instructed the deputy clerk to not advise candidates on these matters, to not create an issue as we are seeing today. The question that I have, Attorney Dale, is do you believe that the deputy clerk has the ability to create an estoppel?
I believe the deputy clerk had the ability to create an estoppel. So my understanding of estoppel and waiver in terms of the way they're applied in a legal sense, the way I'm used to them, estoppel is an argument that if a deputy clerk has taken a certain position and issued statements to the candidates about how they can or can't produce the petitions, then he would be stopped later on from changing direction and saying, well, I didn't give that advice. So I guess the question you're asking is, I guess it goes back to the authority question. Did he have the authority? And I guess based on how Mr. Young viewed it, he did believe that the deputy clerk had this authority and that advice was being handed down. And we heard in other cases testimony that was similar. I'm not entirely sure I can answer the question about whether that creates an estoppel issue. I certainly think it establishes a pattern that was relied on by at least more than one candidate.
Certainly. Ms. Gandersky, can you answer that question? Or do you have any thoughts on that?
So typically, yes, typically a municipality is not bound by the acts of its one agent, where an agent or an employee makes a mistake or gives wrong information. There's an older case called Scanlon. It's a first district case, and I can't remember the citation off the top of my head, but that goes way back to my younger attorney days when I used to have that case in my back pocket often. There is case law that does state where a city employee has made a mistake. The city is not bound by that mistake, because mistakes do happen. I will tell the board though, and this case came up, and it's something that should just be noted. And I'm sure, I don't know if council, all of you are adept in this election litigation, but there's a case called Mertz versus Boldenberg. Bolberding Senior. And that is a first district appellate court case. And it goes back to 1981. And the court did talk about estoppel there, where, and the court kind of confuses the issues a little bit, because it speaks about candidates not having enough signatures on the petition, but the clerk's office had given out the wrong number of candidates for that 5% statutory authority. And the clerk's office made a mistake, giving the wrong number. All the candidates relied upon it. And the court said, well, the statute is mandatory and you must meet the 5% of candidates citywide. But in this case, since the clerk made a mistake, we think that for estoppel reasons, there was substantial enough compliance. The candidates should come back on the ballot, but essentially court chastises, this is the city of Des Plaines, don't do this again, right? Get your numbers right. So that's a 1981 case. That's the only case I found which talked about detrimental reliance and estoppel. The rest of the cases, in line with municipal law, really don't speak to that effect. They say where an employee has made a mistake or is given wrong information, everyone's charged with knowing the law, and the city's not bound by that. So that's what I can give you in the form of election law. I don't know if council want to speak to that case.
May I address that quickly, if that's okay? So MERS was actually cited in my brief, I believe, and the two cases that talk about city clerk mistakes were analyzed by the MERS opinion. And there are 2 or 3 very important things in that case. The first is the court found it important that the person who asked the clerk for information didn't actually know what the rule was. So here, that's part of the reason why I asked Mr. Young whether he knew or not that the petitions needed to be bound. So in MERS, the court said, well, these people didn't actually know what the rule was, so we're not going to hold it against them for having relied on the city clerk. And they distinguished that from other cases where the person actually did know what the rule was, as Mr. Young knew what the rule was, and said that they could not detrimentally rely on the clerk because they knew what the rule was when they came into the office. And that, the Paulus case, and I forget what the other case in there was. The second thing about MERS that is important to know is that the question of law was complicated. So it was about the calculation of the number of signatures and what year was supposed to be used. And there was significant controversy over it and dispute over it. It wasn't a clear statement of this needs to be bound, this needs to be numbered, you need to file your statement of interest receipt. It was a complicated question of law that the clerk gave an opinion on, and the court said that that opinion needed to be relied on, but it said never again. And it said, we're really not going to do this. And the only reason we're doing it is because it was complicated. No one knew the answer. We're giving you the answer, and we're not going to do it again. But the question before the board now is not a similar question. And the other very important distinguishing factor is that Mr. Young actually knew about the binding requirement, which completely distinguishes it from the MERS case.
May I very quickly address that issue, because I don't think that Mr. Mullen's statement is accurate. It's not that Mr. Young knew exactly what the rule stated. He was aware of the rule, but as we've seen through the testimony and these court appearances, what that rule means, what it actually means to bind or to fasten, is not clear. Mr. Young did not know exactly what that requirement meant. So I want to make sure that it's clear that Mr. Mullen's point is well taken, that Mr. Young testified that he was aware of the rule, but in no way was he aware of exactly what that rule meant. And apparently neither are the courts. The courts don't know what that rule means.
Thank you for that. Okay, so what I'm trying to establish here is can or cannot, or does the deputy clerk have the ability to create an estoppel? You know, it seems as though, so maybe I hear Attorney Mullen's argument that Mr. Young did testify that he's aware of the rules, but then I also hear, you know, Mr. Young's actual testimony and Mr. Dale's response here that he may not have understood clearly what was meant there. So what I really want to understand, before, I think the first question that has to be answered before we, at least before I'm comfortable moving forward, is, you know, does the deputy clerk have the ability to create an estoppel? You know, so let's say Mr. Young, we're taking everyone's testimony at face value and that Mr. Young was not aware of the rule. Even if he is not aware of the rule, does the deputy clerk have the ability to create an estoppel in the first, you know? So I think I need that answer. You know, I do know, yeah, so maybe Attorney Ganderski or anyone. We do know that in the last, if I can quickly say, we do know in the last election that the actual city clerk created the board, I think, decided or wrote their opinions incorrectly, but really the decision that was made last election that Mayor Haggerty and I and others went through was that the clerk gave misinformation. And that thereby created an estoppel for all of the candidates. So it was related to, not to signature requirements, but to the filing dates. So, go ahead. Ed or whoever.
And as the attorney that cited that case and argued that before the board 4 years ago, let me tell you that the argument was that it was a complicated issue that went back to the 1980s and 1990s about different referendums and different forms of government that Evanston may have had before adopting its current form of government. And it was similar to MERS, a complicated issue that was honestly never resolved. Everyone was let on the ballot because it was a complicated issue. And you know, that's very different than what we have here.
And I don't think it's that different. I think Mr. Mullen's argument kind of is circular. He's saying it's a complicated issue that previously allowed the estoppel to be created and allow the petitioner on the ballot. I think we've done a pretty good job here of showing just how complicated this issue is, and that, you know, the deputy clerk could have been instructed to provide the same blanket response to every petitioner. The deputy clerk could have said, I can't give you legal advice. I can't give you any answers about how to submit your papers. I will just take them. You're on your own. And I think even that's a warning that I think a lot of us as counsel are familiar with, where people say, I'm not a lawyer. I can't give you legal advice. The same instruction could have been given here, and maybe in the future that's something to consider, because that clears up all the issue. Then the deputy clerk is saying at the outset, I'm not giving you advice. Do not rely on what I have to say. I'm just here literally for you to hand these to me. But that's not what we have here. That admonishment was never given. So I think it is a complicated issue.
I would say that admonishment was given by me, as the deputy clerk acknowledged. It just was not followed, as the deputy clerk reports to the city manager's office. Okay, so it seems as though the deputy clerk may not be able, I'm still a bit unclear. I think it's maybe complicated to figure out if the deputy clerk is able to create an estoppel. Ms. Ganderski, you know, I, as the clerk, did put out information, you know, regarding the binding requirements. So I just do want your opinion on whether or not that you believe the deputy clerk could create an estoppel or create, you know, bind the city. I do know there are plenty of cases where, you know, board employees do not have the ability to create an estoppel. I mean, Attorney Mullen, I think, cited some of those cases and mentioned it here in his argument. The only difference here is that this is the deputy clerk. So do you have an opinion on this, given the testimony?
Sure. Well, I have to be careful about giving my opinion based on how the board should go on this case, but what I can guide you in saying is that generally speaking, estoppel is not something you see happen with municipalities or employees, even employees that give wrong information. I think the board should examine the facts in this case, clearly review the testimony from Deputy Clerk Gomez, take a look at all the factors, consider what was posted on the city's website, what information was testified to by Mr. Young, and considering all those facts, determine if there was some sort of a detrimental reliance, which is really, that's a question of law based on the facts. But beyond that, even if there was a detrimental reliance, doesn't matter. And my understanding is with regard to the case law, no, the statutes are strictly construed. Now, the caveat to all of this, and this is where this gets complicated, is the cases are case by case by case. Binder clip, paper clip, folder, accordion folder. And so the courts have given different examples of what should be accepted and what should not be accepted. So I think what I would advise the board to do is re-examine all the testimony that you've heard and the facts in light most favorable to the candidate, because it is the objector's burden of proof by the preponderance of the evidence. So is it more likely than not true that what the objector is saying should remove the candidate from the ballot? And is the testimony that you heard providing for substantial compliance with the Illinois Electoral Code?
Okay, that leads me to the next issue. So the substantial compliance, I'm sorry.
Clerk, you've had the floor for a while. I know
Sure.
Alderman Rainey had some. Do you mind yielding it to another member?
Yes, I will yield to Alderman Rainey.
Thank you. Alderman Rainey.
Well, I don't mind if he finishes. I just wanted you to know that once he's finished, I'd like to
Want to
speak.
go? Okay, all right. Go ahead.
I didn't know if he was, ever going to finish. So.
Okay, all right. Go ahead,
finish.
Clerk Reed.
I have a few more questions. So substantial compliance. Attorney Dale made an interesting argument, almost aching of the glove does not fit with the book form. It does, so what is the standard that we should apply here? It is, slightly, I'm not going to say convincing. There is something interesting about the argument that, Mr. Young made an attempt to, comply. So, Attorney Ganderski, can you maybe give guidance to the board on, should we be looking at substantial compliance here, or should we be looking at strict compliance when it comes to the binding or the fastening of petitions?
In my legal opinion, the issue in this case involves whether or not the candidate substantially complied with the statute.
Okay, so you don't think it's strict compliance when it comes to fastening?
I think where this gets confused is the courts have said the statute is strict, it must be followed. But on the case by case basis, was what the candidate did good enough? Does that make sense?
Yes. So yeah. Okay. So you're saying that the lens that we should be using.
So for instance, if the papers were, I'm just going to make up a silly example, but if the papers were crumpled up into a ball and tossed at the clerk and said, "Here are my nomination petitions," I think we can clearly say that the statute was not strictly complied with.
So I mean, in a serious sense, if they were just submitted as loose papers, with no attempt to bind.
No attempt to bind, loose papers, I think that's pretty clear. The issue is, the courts contemplate whether paper clips are good enough, binder clips are good enough, folders are good enough. Is that enough? And, the reason for that is what we've heard counsel argue is that it's about the integrity of the papers themselves. The courts are concerned about the papers being shuffled, misplaced, something fraudulent happening with the papers. So it's really, to me, it appears to be a chain of custody issue.
If I may, I would just like to point to the Bendel case, which I cited, that says, inasmuch as Section 10-4 is mandatory, compliance with its provisions must be strict rather than substantial. And the next paragraph says, turning to the facts of this case, we must now determine whether plaintiff strictly complied with that section by securing his 6 to 8 nominating papers with a large paper clip. And that's direct language being read out of the First District Court of Appeal opinion.
And
Right.
that case involved a serrated paper clip, which the courts distinguished is different from a regular paper clip because the papers couldn't easily be pulled apart. And I'm just
Yeah,
going to advise, just because I want to make sure this process remains completely fair. If the board has questions for you directly, counsel, then please answer. But I'm going to ask the arguments over at this point. So Mr. Mullen, thank you for that. But I'm going to ask that everybody just remain silent until the board has direct questions.
Thank you, thank you. Okay, so then reading that, I do have the Bendel, if that's the proper pronunciation, case in front of me here. And what I am reading here is that the standard, there, as Attorney Ganderski rightly pointed out, was that the reason that they held that paperclip was sufficient is because if it says that the board employee attempted to pull the pages out of the petitions, and when they attempted to pull the pages out, they could not remove the pages from the petition. It seems as though, while Mr. Young did make an attempt here, that if someone were to try to pull a page out of the folder, there is potential for that, but also there's potential that if it's in the folder, maybe it can't be pulled out readily. So, I guess I will rest for now, but I think that's where we should, fastened at one edge. I mean, it also says, the code also says that it must be fastened at one edge. That is within the code. And it does not appear that these petitions were, fastened at one edge. It does seem that there was an attempt to put them in some kind of book form where they were secure, but it does not appear that they're fastened at one edge. And the law is clear. The reason the statute is mandatory is that it says if, these provisions, the candidate meets these certain provisions, if they aren't complied with, then no signature, on that petition shall be counted. So I'll yield for now to Alderman Rainey.
Alderman Rainey.
Thank you, Mayor Hagerty. Well, first of all, I just want to give an overview of my feeling about so many of these objections. Regardless of the clerk's direction to the deputy clerk, don't give advice, and I have no problem with that. What is so wrong about putting a stapler on the counter or on the desk when people are coming to file their petitions? Every time I've ever gone to file petitions, there's always been a stapler out. It's almost a malevolent act, not for the city clerk to put a stapler out when people come with their petitions, because there's always somebody who didn't have their petition stapled. Second of all, any city clerk who sees somebody coming with unstapled petitions automatically says, I'm not accepting those, go away. And so petitions not stapled aren't even accepted. So many of these. I'm sorry. Do not interrupt me, clerk.
Well, this seems political,
I'm
Alderman
sorry.
Rainey.
I'm giving.
You're not speaking to the case. You're speaking politically.
I am getting ready to get to my point. Why did the deputy clerk accept all these petitions? Where was the city clerk? I don't understand why the city clerk wasn't doing his job during the acceptance of the petitions. I don't even know if the deputy clerk has the authority to accept petitions, but let's say he did. In this case, I do believe the deputy clerk misled this applicant. I believe the applicant was misled. I do believe that the applicant understood that he needed, regardless of the test, I believe he understood that the petitions needed to be secured. I cannot understand any applicant coming with unsecured petitions. That's common sense, that you would secure your petitions. But I do believe that at the point where the deputy clerk said, no, that's okay, you can submit them like this, I'm going to Xerox or copy these, I have to copy these, that I do believe that he was the applicant, that the candidate was given permission not to then secure those petitions. So on that point, I'm going to support I'm going to support Young. I'm not going to support the objector on that particular point. I mean, just to go back, the city clerk ran workshops, et cetera, encouraging candidates, encouraging people in the city of Evanston to be candidates for municipal elections. And then it comes time to file petitions. And it almost seems these roadblocks were thrown out so that.
Alderman Rainey, this is inappropriate. This is political and inappropriate. There are no roadblocks. This is highly inappropriate that you're using this for as a political.
Taking all this time
margin against one of your opponents.
To get rid of candidates because they didn't have their petitions secured. I think it's a roadblock. It is. But anyway, so in this case, I'm supporting the candidate.
Thank you, Alderman Rainey. I have a question for the objectors, the council of the objectors, and I just want to answer to the question. I've heard your arguments. I've heard opposing counsel's arguments. I understand the basis of why we want to, securely fasten these petitions. Mr. Foster made that point earlier about, if they're just loosely provided, somebody could, take something away later, add something later. And so integrity matters. And I do believe integrity matters. Ballot access is also really important. And we're trying to weigh those. So my question of Mr. Mullen and Mr. Foster is, I didn't hear you say during this proceeding, but are you alleging any fraudulent activity by the other candidate or the clerk's office in terms of adding or subtracting any documents from the filings?
Absolutely not.
Okay. Mr. Foster?
Absolutely not. The issue here is that
I understand.
If we don't enforce these rules, then there's an opportunity created.
I understand the issue, but there's no allegation that there's been something added or subtracted. Could I just ask that question of Mr. Gomez?
Can you hear me, Mayor Haggerty?
I can hear you. So it's the same question for you. Once these documents were turned over in this manila folder or envelope to you, I understand you went and you photocopied them. They've been in your possession. Has anything been added or subtracted from these documents?
No.
Were these documents numbered with page numbers on the bottom?
Can you repeat that, Mayor Haggerty? You cut off.
Were there page numbers to the documents submitted?
I don't recall.
Okay. Mr. Dale, do you recall? I know there's a number on the bottom of the pages.
I can answer that, yes.
You have to, well, I'll just ask Mr. Dale as the counsel, and I asked that of Gomez because he received them. Mr. Dale?
I'm sorry, Mayor Haggerty, could you repeat that question?
Oh, I'm sorry. Am I breaking up on people?
No, it's not that you're breaking.
I was asking if Mr. Young numbered the pages. I understand they were put, and we're having an argument over whether this is a substantial mistake or not when they were put in the manila envelope. Were they numbered though in the envelope?
No, to be totally honest, Mayor Haggerty, I can't recall.
They were numbered. We will.
They were numbered.
See that they were numbered. And,
okay.
And the exhibit that I introduced earlier shows the number on the page, and I cited the number, so they were numbered.
Thank you, counsel.
Okay. All right. Oh, thank you. I am, you know, again, I appreciate the work on both sides of this. I am, you know, arriving at where Alderman Rainey is right now, which is to deny the objection. And I would like to move to deny the objection of the buying of inappropriate.
I'll happily second that.
Let me see if there's a, let me see if there's a,
Second.
all right, you can second now.
Hold on.
All right.
I'm gonna ask everybody, the court reporter is waving her hand. She cannot take down, you guys talk over each other. So there was a motion made. Is there a second?
So I made the motion to deny the objection. Clerk Reed seconded it. Now it's Clerk Reed's got the floor.
All right, I just do want to, you know, I think these are local electoral board hearings. I am supportive of, you know, long-time supportive of moving this up to another body and not having these local boards hear these cases because, as I've said in the newspaper, that they are, you know, inherently, you know, undemocratic, and there's some bias that works into this. We're seeing this with, you know, Alderman Rainey using this as a political bludgeon. Ms. Gandersky, do you think it's appropriate, just for clarity, because this was raised as a part of why we are coming to this decision, that, you know, folks come into the electoral office, any electoral board or body, and I'll ask this of the two attorneys, where you come into the office unprepared to file your petitions and you get arts and crafts supplies from the office for your political petitions. You start getting a stapler, you start writing numbers on pages, you start binding things, needing a hole punch. Do you think it's appropriate that people would come into the office where they're filing their petitions and then, you know, knowing that when you turn over your petitions to the election authority, that they are the property of the election authority and it's clear in the code that those petitions shall not be altered at any point after they're turned over? Do you think it's appropriate that that election authority provide, you know, pens and staplers and art supplies for folks to get their petitions in order? Or do you think it's appropriate that the local election authority take a hands-off approach and simply accept the petitions as they are turned in?
All I can say is that this board is charged with applying the law to the facts in each particular case. If the question is, does the law require the clerk's office to provide a stapler? There's nothing in the statutes that require that. Whether that's a moral issue is another story, but that's not, you know, for me to opine on. I'm only to opine on the law. So I can tell you that there's no statutory requirement.
Certainly.
Is there a motion on the floor?
I did do a motion. I don't really hear us talking about the motion.
We're talking about the motion. We're voting on whether or not to accept these petitions. In part, Alderman Rainey is raising the issue that, you know, in part because she believes a stapler should have been provided by the clerk's office, and pens and papers and hole punches and all kinds of materials for folks to, as they're filing their petitions, alter their petitions.
Let's move on. Let's move on with the vote. All right. So we've got a motion. It was seconded. Clerk Reed, how do you vote?
Can you repeat the motion to deny the objector's petition?
The motion was to deny the objector's petition.
Wait a minute. Just on that one issue of the binding, the one objection of binding.
Just on the one. This is just on the one issue of the binding, correct?
You know, this is very difficult. You know, the law seems clear that the petitions must be fastened at one edge, and it does appear that they were not fastened. But then the other standard is whether or not it seems as though you know, whether or not the deputy clerk creates estoppel, and whether or not, you know, making some attempt to put them in you know, making some attempt to put them in book form is within substantial compliance here. And I vote present.
All right, so you vote present. Alderman Rainey, is it?
Aye.
Alderman Rainey, how do you vote? I vote aye. Aye, correct. So you vote to deny the objection, unbinding. I vote aye as well. Ms. Gandersky, I just want to make sure, so for the board members, is a vote of present acceptable, or do we have to vote up or down on this? If it is acceptable,
the way I understand the election code, the way that I understand the election code, there has to be a yes or no vote.
okay. And Clerk Reed, I just need your vote.
Okay, well then, given that there was, in this case, some attempt to, secure the petitions and that he put them in a folder, and that Mr. Young testified that he relied on the testimony of the testimony of the deputy clerk, and given that, it is my belief that candidates should have the right to run in this instance, for this case, given the facts, I will vote aye.
Okay, all right. So on a 3-0 vote, the objector's objection has been denied on the issue of binding. Ms. Gandersky, I know we have been at it for quite some time. It's 12:15. I know that Mr. Foster will want to argue the other objections that they had. And I know we have a lot of other candidates and petitioner and their attorneys here. I also can tell you on my own schedule, I am booked with things this afternoon that I can't reschedule. So I'm looking to you for what your suggestion.
Quorum is 2, so we
A
can continue the
quorum
hearings
is
without-
2. I suppose you're right. I could step aside and either we have 2, or I don't know if there's another, if Alderman wins. Well, she can't hear this case. But she
given
could
that this
possibly
was
help
the
with
board that heard it, we
case.
wouldn't, given that this was the duly constituted board, we wouldn't need to appoint an alternative for your absence. We would just continue with the quorum of the 2 members who are here for the entire testimony.
Mayor Hagerty, when is your next appointment?
I've got to step aside at 12:30 for probably 10 minutes, and then I've got a 1 o'clock, and then if we did a break, let's just see here. I could move my 3:30. I can't. I've got a 1 to 2 that I have to be at, and I could return after that. I can move my 3:30, and then I could be available till 4:30. So I could be available from 2 to 4:30.
If you want my opinion, I think we can finish this particular matter, this consolidated matter with Mr. Foster's objections today, and possibly, just the way that the schedule's been going, possibly one other matter. I don't see, unless there was a lot of brevity, I don't see the board being able to decide all matters today. So that said, if the board wants to come back this afternoon to finish Mr. Foster's objections and possibly one other matter, I think we can do that, but I think we're looking at another date regardless.
So I may be able to.
I agree. I think.
Oh, I'm sorry.
Go ahead, David.
Yeah, Mayor Hagerty, I have listened to this board, and I have given special attention to the approach that's being taken here. As you know, we withdrew objections 2 and 3, and I'm advising now, in light of everything that I've heard, that I'm going to withdraw objection 4. So this matter can be treated as closed.
Thank you, Mr. Foster. So you are withdrawing, and again, you're representing Whitcomb and others. You're withdrawing objections 2, 3, and 4, which would have been the next items that we would have heard. So Ms. Gandersky, then, how about this? How about we wrap up right now with what needs to be done? Because I know you and your staff need to do a little work. And what if we came back at at 2:00, and then met from 2 to 4:30 today to handle another case or two, and then schedule a time if other board members are available for tomorrow morning at 9 a.m. to resume additional cases that are outstanding.
I think that's very reasonable. And just a reminder to the board, we do have public comments on the agenda today. So just to make sure that's all included. I think we can work on the order in between the recess today. And then when the board comes back this afternoon, we can just enter an issue out the order and then go on to the next case.
May
If I can,
for just a moment, please?
if I
Go
can
ahead.
speak.
Let's go ahead with Mr. Mullen and then Mr. Reed.
I've had a lot of opportunity to speak today, but I know there are several attorneys who have been on this call since 9 o'clock and their case has not been called and they've been sitting here. And I appreciate that this is a public board meeting. In a lot of cases where you have more than 3 or 4 objections, if we could decide that which 2 go forward in the afternoon and which come back on Fridays so that those attorneys don't have to sit from 2 to 4:30, I think they would appreciate it. And I'm taking the fall for them to ask you to do that.
Agreed.
Sure.
Agreed. We'll do that.
I also do think it's prudent, given the expedited nature of these, that, Mayor Haggard, if you are unavailable for, the next 2 hours, I do think it's prudent that Alderman Rainey and I, I'm available. I've made myself available for today, understanding how many cases were before us, that we, move forward with a case in the meantime. Particularly, there's one case with, for the city clerk's office, with Jane Grover, where it potentially will require a records examination, which is an order that we'll have to give to the Cook County Clerk's office. And then, candidates and their, the objectors will have to go and go down to Cicero and, sit. And so, that will extend the process by, some time. And so I think we can, deal with that case so we can get the ball rolling on the records examination. There's another case similar to this where petitions weren't bound. So maybe Alderman Rainey and I can hear that case, or, what other objections are left. Let's see out there. I certainly think we should get to the Grover case.
Grover
I think
case, we need 3 people.
I'm sorry.
On the case.
I didn't mean the Grover case. Oh yeah, I did mean the Grover case. Well, why do we need 3 folks as opposed to?
Because I think that's a more complicated case. But
No, it's actually
why don't we do the Mendoza case next?
I guess the 2 of us can do the Mendoza case, and maybe the 3 of us can do the Grover case. I think the Grover case is fairly straightforward as it's a records.
Do the Grover case at 2:00.
Okay, so maybe we'll do the Grover case at 2:00, and maybe Alderman Rainey and I
want it to be, and this is the way that they would do it in court. The counsel are being presumably paid by their clients, and their cases usually go first. So I have counsel on, I have Mr. Mullen on Jefferson versus Mendoza, and I've got counsel on Russell versus Revelle. And who do we have on representing Ms. Carnage?
That's me as well.
Mr. Mullen.
Okay, Mr. Mullen, he's got 2 cases left. So he's here regardless. And then we've got counsel for Russell and Revelle. And my guess, and I don't want to speak for the board, is that Russell and Revelle may get continued. But I have to please ask the board. The law department does need a break. We have to catch up on the order and kind of do a reorg for this afternoon. And none of us have had much of a break this whole day. So I understand Mayor Haggerty has meetings. I also have meetings that were scheduled this afternoon that I'm quickly trying to rearrange to get someone else to cover.
So,
right, so
we'll recess now till 2:00. Want to do that?
Yep, we can. Let's recess now to 2. I'm sorry, Kelly, did you say something? All right, so we're going to recess now. All right, we're going to recess now till 2 o'clock. At 2 o'clock, Kelly Gandersky will come back with the materials from the decision that we just made on these 2 cases. So her staff will bring them back. We will take care of signing off on those. And then because we have Mr. Mullen here, my suggestion would be we put 2 cases on the docket from the 2 to 4:30 today. Willie Jefferson versus Rebecca Mendoza. You're the legal counsel for that, right, Ed?
Yes.
Okay. And the
Jane Grover.
Are you the legal counsel on that one, Ed? Okay.
He is.
Yes. Okay. So why don't we go with item number 4 and item number 6, and we'll try to get those done in the 2.5 hours that we would have. Okay. From 2 to 4:30.
And then just as a courtesy to
And then the-
counsel Russell and Ravel, that will most likely be continued for tomorrow morning.
So my suggestion would be a continuation, if the other 2 board members can make it, to tomorrow morning with a 9 a.m. start.
Do we have a hard
And
stop at 4:30, Mayor Haggerty?
I do. I do, and Alderman Rainey does as well.
Okay, so we no longer have a quorum. All right. Well, if that's the motion, I second it and support it.
All right. So thank you. We've got 2 on that. That was the motion, and it was seconded. Alderman Rainey, are you an aye on that
Aye.
procedural?
Aye.
Okay. Alderman Clerk Reed.
Aye.
It's just an aye. Okay. And Mayor Haggerty, I'm an aye. So that's the procedure. We will resume at 2 o'clock. And we will hear Willie Jefferson versus Rebecca Mendoza, and then Allison Harned versus Jane Grover. And then we will meet again tomorrow morning at 9 a.m. And at that time, we will hear the 2 remaining objections that we have. It's 2 remaining ones, right? We have Evie Krause Russell versus Eleanor Ravel.
And that's it.
Oh, that is it. Okay, so we will just have the 1 tomorrow morning. If we don't finish this afternoon between 2 and 4:30 with those cases, and that may be a possibility, I don't know where things will go with Allison Harden versus Jane Grover, then that will resume first thing on Friday morning if we don't finish that today. Okay, thank you, everyone. We're going to take a break then and see you all at 2 o'clock.
Thank you.
And we've got Miss Hickey, who's ready.
Okay, thank you, Kelly, and welcome back, everybody, from our break. It's now 2:04, and we will resume our meeting, and we're going to resume it till 4:30 today, when we will break and then have to we'll re-adjourn or we'll recess and then continue at 9 a.m. tomorrow morning on Friday, December 11th. All right, so this afternoon, what I'd like to do is first, I would like Ms. Gandersky to just process the paperwork from our last case that the board handled, which was involving Eric Young, a candidate for the 3rd ward. Do you have the paperwork prepared for that, Ms. Gandersky?
Ms. Ruggie, can you share your screen so that the board can review the order? And Clerk Reed, are you here? I didn't hear if Clerk Reed is here. I see that he's on. His screen is not on.
Oh, my screen should be on now. Sorry, I'm here.
There you are. Okay. Ms. Ruggie, that's the caption. Can you scroll down?
So I'm just going to ask the board members if you'll take a minute, review this, let our legal counsel know if you see anything that's of concern or any requested changes you might have. I'm okay with this first page if the other members are.
Right. I'm good.
Okay, clerk reads good. Okay. I'm good with this, if the other board members are.
Good.
Just give me a thumbs up, Clerk Reed, when you're ready. Okay, so we just keep
Oh, I'm
scrolling.
sorry.
down.
I didn't know I was muted. I thought I
Oh,
was.
that's okay. Yeah, you can find to be muted. Just give me a thumbs up, whatever. All right.
What I was going to ask is, Miss Ruggie, can you maybe F11 your screen? If you press Control F11, I believe it'll full screen. Make it a little larger.
Sorry, I don't think that.
I'm definitely squinting here.
You should be able to press the function. Are you on an Apple or a?
Yeah, I have an Apple.
Oh, so then it's the whatever that Apple key thing is, and then I think F11 as well.
I think you just made it smaller. Okay, I finished this.
Oh, that doesn't help.
You can click on the
Okay.
green circle and it'll get bigger.
The green circle.
The green circle in the upper left. Kind of hover over it. Yeah, and then go whoop, and it gets bigger.
And plus.
Did that make it bigger?
It didn't really make it bigger.
Yeah, but whatever. we're good enough here. All right.
Try Command and then plus.
Yeah, command plus.
No, sorry.
That's equal. Yeah.
There you go. That's bigger. That's good.
Okay.
Should I scroll?
Yep. Yes,
Yes.
please.
Oh, wait, I'm sorry. It said the board found that. Okay, okay. It's strange that we're using that it was unfastened specifically in the manila folder, but.
I sort of agree with that. Is that necessary, Attorney Gendersky?
Well, I mean, I think it was undisputed. Doesn't the board want to list how the petitions were turned in?
I mean, they were submitted clearly in a manila envelope.
Yeah, I
don't
mean, if
know
we say they're.
unfastened, I don't know necessarily.
All right, we strike the word unfastened, Alex, please.
Did someone raise, I apologize, maybe I don't recall, but did someone raise the Druck v. Illinois case?
No, this is just the primer language.
Okay. Should we be, given that it wasn't raised in the hearing, is it proper to put it here now?
Yes.
Okay. Can you just tell me why? I apologize.
Sure. So this is a finding. This document's called a findings, decision, and order. So it has to list your basis for the order and putting the applicable law. Courts or judicial bodies can, take judicial notice of the law.
But
So
we didn't use, I know I didn't, and I don't think, since it wasn't raised in the case, I don't think Mayor Haggerty or Alderman Rainey, separately looked at the Druck v. Illinois case and used this in our determination here.
well, I looked at it, and the main case here is the Pucci versus Cook County Officers Electoral Board, which I believe was also mentioned in one of the briefs. So some of these cases recite other cases, and it's very standard to have primer language like this in an order like this.
I'm okay with it. If everybody's read that, can we scroll down?
Yeah.
Okay.
Oh, yeah. I also don't feel like this last paragraph supports what we did. Yeah, I don't fully feel like the last paragraph, am in part actually, the reason for my vote the board just a few hours ago voted to remove someone from the ballot for lacking strict compliance. And my reasoning for having a different opinion in this case, I was not involved with the other one, but in this case was that, potentially an estoppel was created. And it seems as though the last paragraph here actually goes against that.
Kelly, this is Steve. I'm wondering, let me put screen on. I'm wondering if we don't take this evening for you and your staff and the board to take a closer look at this rather than rushing through it right now. And then tomorrow morning when we meet, it will give us this evening to make sure that we are comfortable. This is an important opinion or paper that we're issuing on this because it certainly affects other cases that are going to come before this board. And so I'm just wondering, and then if we issued it tomorrow morning, if that would give you and your staff, as well as Alderman Rainey and Clerk Reed and myself, a little more time to make sure we're comfortable with the rationale and everything that we're presenting here.
That's fine. Just keep in mind that everybody on this case has to come back tomorrow morning to get the order.
It would just be to get the order, though, not to argue cases. Alderman Rainey.
If I can also cite, I'm sorry, I'll let Alderman Rainey go.
All right, Alderman Rainey, what's your thoughts on that?
I feel comfortable with that.
Okay. Are you okay with that, Clerk Reed?
Yeah, I just want to cite the statute. I'm sorry, I meant to send this to Kelly when we were offline. The person doesn't actually technically have to be present. We should be mailing it to folks anyhow and by certified mail. And when they receive it, that's when they are, the decision is effectuated.
That's not the way I read it. It's that you guys haven't quite made a decision yet because the order isn't effectuated. So I think everyone needs to come back tomorrow.
No, okay. Well,
so let's do that. We've got to.
I just do want to point, yeah, we can do that, but just for Ms. Gandersky, 10 ILCS 510-10, a copy of the decision shall be served upon the parties to the proceedings and open proceedings before the electoral board. If a party does not appear for receipt of the decision shall be deemed to have been served on the absent party on the date when a copy of the decision is personally delivered, or on the date when a copy of the decision is deposited with the United States mail in a sealed envelope or a package with postage prepaid addressed to each party affected by the decision or such party's attorney of record, if any address is on file. So we do.
I read the same statute, but what I'm telling you is that this is COVID and this is done via Zoom. This is the first time this is done via Zoom, and the parties are present here today. What considers present is, a question, and I think that the board should decide when it signs the order, that's the date of the decision, and the parties, my understanding is, want to be present. So I would not advise, signing this and then mailing it off without the parties present. That's my advice. The board can do it.
We got a lot to cover this afternoon.
Well,
Let me
no,
just
hold on, Mayor Hagerty, this is really important.
Clerk
Mayor
Reed,
Hagerty, 1 second.
Clerk Reed,
For a second.
Clerk Reed, you have been speaking constantly for the
It's our
last
job.
several
That
hours.
is our job.
Clerk Reed, if you would just take a second, please. My suggestion was going to be just to ask the attorneys, because they are here right now, if they are okay, if we take this evening to look more closely at this opinion, work with our legal counsel to the board, and then convene as we are tomorrow morning at 9 a.m. and issue this.
I'm fine with that. It's fairly standard for the board to recess and write an opinion and then come back, and we would waive our presence, and we would allow for service by email of that.
Thank you, Mr. Mullen. Mr. Dale and Mr. Foster, are you okay with that?
I'm also fine with that as well.
Thank you.
We did not do that in the case earlier, and I would just recommend that we do put it in the mail just to make sure that the board is complying with the statute. We did not ask the two parties earlier if that was fine.
Okay, we can.
Well, they've already confirmed receipt. At least one party did, so we can take care of that too.
Okay, so we will, Kelly, make sure each of the board members gets a copy of this, okay? And if board members, have concerns, what I would suggest is talk to Ms. Gandersky directly, and then the three of us will convene and talk about this tomorrow morning. But if we can have a chance to see this this evening, that would be good. Let's go ahead now, and I'd like to move to case number 6 right now, which is case number 20-MOEB-EV-04, which is Allison Harned versus Jane Grover. Before we begin the proceedings on this case, Ms. Grover asked for a minute to have the floor, so I'm going to grant that to Ms. Grover. Are you with us? There she is. All right,
Yeah.
welcome. If you could give your name and spell your name for the court reporter, Tina Hickey.
Thank you. My name is Jane Grover, Grover. My pronouns are she, her. Thank you, Mayor Hagerty. Thank you, Board of Electors. I consider myself a public servant committed to serving this community of Evanston. I believe in the role of the city clerk to advance good government, openness and transparency, compliance with the Open Meetings Act and the Freedom of Information Act, as well as the clerk's role in providing quality customer service to city staff and to residents. It's ironic in a sense that my 2 appearances before the electoral board this year can be counted as additional relevant experience for the office of city clerk. However, after a consultation with new election counsel who has reviewed the pleadings in this matter and applicable law, it is with sincere regret that I withdraw my motion to dismiss. Whatever the electoral board's decision would have been here, I do not think I would prevail on appeal. So thank you to the electoral board and to the city attorney, Gandersky, for your time. I do not want to use more public resources on this matter. Thank you also to Clerk Reed, Deputy Clerk Gomez, former clerks, city clerks Rodney Green and Sandy Gross, and to the League of Women Voters of Evanston for their insights on the city clerk's work. And really mostly thank you to my friends who put themselves out there to circulate petitions during a pandemic. I hope the state of Illinois someday will establish a system for electronic signature petitions. And thank you to the hundreds of Evanston voters who supported my candidacy in so many ways, including signing a petition. It was not enough this time. And again, I don't want to use more time, including the objectors, to litigate this matter. So thank you, Electoral Board. Thank you, Mayor Haggerty. Ms. Gandersky, do you need me to file something to withdraw the motion, or is my statement sufficient?
Ms. Grover, I just want to make sure that we understand clearly from the record. So your intent is to withdraw your motion, and are you withdrawing your candidacy?
I am withdrawing my motion, which means the objection stands, correct?
That would be,
No.
well, it would,
Well,
there would be
no,
a
because it's
clerk
I
read-
will move a motion. Let's let Ms. Gandersky finish. Go ahead.
no. That your pleading has been withdrawn, but you still have a right to defend the objection if you want to.
No, I withdraw.
So I'm gonna move that we sustain the objection filed by Allison Harned in case number 20-MOEB-EV-04. Is there a second?
I
Is there a
second, but I don't know if that's the proper procedure here, because I mean, well, maybe we can, I don't think that's the proper procedure, given that we don't, I think that Ms. Grover would have to submit the withdrawal of candidacy document, given that what we have to do now is a records examination, and we still don't know if, at this point, if those signatures are valid or invalid. Unless, and I don't recall, I think that Ms. Grover presented on face value more than enough signatures to meet the minimum threshold. I mean, it's fair that she withdraw, but I just think the proper way to do that wouldn't be necessarily to sustain, as if we know that she did not turn in enough signatures. We haven't done the records examination. I think that the
Ms. Grover, are you okay if we move a motion to sustain the objection?
I'm fine with that. Thank you, Mayor Haggerty.
All right. Is there a second to my motion?
I seconded it already.
All right, thank you, Clerk Reed. All right, we're going to take a vote on the motion to sustain the objection. Alderman Clerk Reed?
No.
All right, Alderman Rainey?
Aye.
All right, and Mayor Haggerty is a reluctant aye. And the reason I mentioned the reluctance is, again, I think all three of us on this election board, want ballot access. We want, people in Evanston to run for office. We want competition for these different offices. Obviously, Ms. Grover's removal here means that there won't be any competition for the city clerk position. There is only one other candidate, Stephanie Mendoza, who therefore, if on the ballot and she hasn't been contested, will be the next city clerk of the city of Evanston. So thank you, Ms. Grover, for looking at this closely and valuing the time of this election board and people here in Evanston. We're now going to move on to the next case this afternoon, which is case number 20-MOEB-EV-02, which is Willie L. Jefferson versus Rebecca Mendoza. And this is for Rebecca Mendoza's candidacy to be on the ballot for the 5th ward. So I'm going to, at this point, ask Attorney Gandersky if she will lead the proceedings on this case.
Good afternoon, everybody. Kelly Gandersky again for the city of Evanston. Do I have counsel for Willie Jefferson present?
Yes, Ed Mullen.
Okay, Mr. Mullen is back. And do I have Rebecca Mendoza here today?
Yes, I'm here.
Okay, Ms. Mendoza, are you being represented by counsel?
I am not. I'm representing myself.
Okay, very good. We have received your pro se appearance, and I have Mr. Mullen's objection petition. I did not receive any other pleadings in this matter. Have any other pleadings been filed before we begin?
I don't believe any pleadings were filed. I thought I emailed you an appearance, but if I didn't, I will.
Okay, very good. Well, you've signed the petition as counsel of record. Okay, Ms. Mendoza, you were placed under oath already on Monday, so I just want to remind you, you're still under oath. we should proceed with Mr. Mullen, case in chief. Mr. Mullen, I'll give you 10 minutes. Ms. Mendoza, I'll give you 10 minutes in response. And there will be 5 minutes thereafter for rebuttal. But keep in mind, we did already take some testimony on Monday. So I would ask that both parties be brief, especially if you feel that any of it would be repetitive. The board was here on Monday and heard much of the testimony already. Before we begin, are there any lay witnesses to be called or recalled?
No.
Ms. Mendoza? No.
No.
Okay, Mr. Mullen, you have the floor. Ms. Ruggie, can you please set the timer for 10 minutes?
I'm going to set my timer for 5 minutes.
Okay, thank you.
So here we have a case where there's no dispute about whether or not there's compliance with the statute because there was no staple, no file folder, no prong fastener. The petitions and nomination papers were filed loose. So the question of strict compliance and substantial compliance that we discussed earlier today is not really relevant in this case because there was no manila folder or anything else involved. The second point I would make is, again, the candidate acknowledged that they knew when they walked into the clerk's office that the petitions were supposed to be fastened, and indeed her statement of candidacy says at the top of it, attached a petition, and her petitions say bind here. So I think the question then is whether the conversation that Ms. Mendoza had with the deputy clerk is sufficient to create, whether you call it an estoppel or detrimental reliance, whatever legal theory it is, whether or not it's enough to mean that this board should or does accept her nomination papers. And I believe that the answer to that question should be no. The first reason for that is, as the Chicago Electoral Board found in the Valentin case, where it addressed a very similar issue here, that is not the role of the clerk, and the clerk cannot really bind the city. And we've presented that case to the board, and I believe even in the previous order that was proposed for Mr. Young, that case was cited in that draft order, so the board is well aware of it. And that's the only case that I'm aware of in any electoral board or otherwise where this issue has been decided, and it was decided in favor of the objector and against the candidate. I'd also, for the record, like to re-mention the MERS Voberding case that we cited, and the cases within that cited regarding the ability of the city clerk to bind the city, and the, pardon, one second. The Paulus case at 70 ILAP 2nd 97, and the Sinclair refining case at 246 ILAP 152, which both stand basically for the proposition that if a clerk gives a permit or gives permission to someone to do something, that doesn't allow them to violate the law. And I was informed during our break that Evanston has in fact argued this in court with respect to giving out zoning permits, and said that the clerk was not allowed to do that in violation of city law. So I think you have to think about what precedent this sets for the city and for the law. Particularly in election law, where are we going to allow the clerk essentially to rewrite the election code and talk about what's required in the statement of economic interest, what's required in the statement of candidacy, whether something needs to be notarized, whether it needs to be numbered, where do we stop when we open that door? I would like to respond to a few of the issues raised during the debate. And I do think it is wonderful if the clerk has a stapler in their office, but I also think that a candidate filing to run for office should be able to find a stapler to bind their petitions, especially if they know that that's something that they're supposed to do. There was also a discussion about whether anything was actually added or subtracted to the documents, and no court has really found that issue relevant. And the kind of analogy that I would use is, if you get a ticket for not using your seatbelt, is it really a defense to say, well, I wasn't in an accident? And I think the answer to that is no. It is there to prevent something from happening, and that's why we're required to follow the law. And then there was also a suggestion that the fact that the petitions were numbered was sufficient to satisfy the purpose of the binding requirement. But again, all of the cases that have looked at this issue, regardless of how they've come out, have not found that the numbering has been sufficient to satisfy the requirement for the binding requirement. Those are two separate requirements that the candidate must meet. Whether they have the same purpose or role, both of those are separate and independent requirements. And here, it's perfectly obvious that the candidate did not comply with those. So those are the arguments that I'd like to state on the record, and I will end there. Thank you.
Okay, thank you, Mr. Mullen. Ms. Mendoza, you have 10 minutes.
Thank you. I know that you said that for the record, we're carrying over the testimony that was presented on Monday. And so I just wanted to state again the testimony delivered by Deputy Clerk Gomez, in that he did say that I could turn them in as is, as he actively interrupted me looking for something to perforate my paperwork. Which Shelley Castillo's testimony confirmed that she heard and confirmed him saying that it was okay to turn my paperwork in as is, as again, I was actively searching for something to fasten my paperwork. I would like to cite the case law for Atkinson versus Schelling. And ultimately, I believe that I substantially complied with my attempt to submit paperwork as required. And I was, again, attempting to bind the papers in front of the deputy clerk, and he stopped me from doing so. And so he stated that he would accept them as is. So I think, you know, to my detriment in relying on him witnessing what I was attempting to do and stopping it and interrupting the actions that I was attempting to do. Again, there has been estoppel that has been named, and to my detriment in relying on the deputy city clerk. So I believe that, like I said, I was aware and that of the binding rule. And again, I was actively binding the petitions and relied on the direction of the Evanston's local elected official to not continue binding my petitions. I believe that this is fundamentally unfair to deprive me of my right to be on the ballot, and by stopping my actions. I think that it is unfair to the legally registered 5th Ward voters who signed my petitions. Again, it's been stated, this has been a different type of election, and where I had to go during a pandemic to collect petitions, which is not very easy to get people to open up their doors to sign this. So I think that sustaining the objection would disenfranchise the voters who did sign my petitions, and it would undermine public faith in fair elections. And finally, I do want to cite argument from Green versus Reed 17-MOEB clerk EV01, in which this relied on estoppel from the city clerk's office. And the decision that was made during that Board of Elections hearing was that that it would be denying ballot access as it pertains to matters of candidate eligibility, matters of equity, and again, voter disenfranchisement. So that's pretty much all I have to present my case, and I would humbly request that the Board of Electors allow me to continue staying on the ballot.
Thank you, Ms. Mendoza, for those very poignant arguments. Mr. Mullen, I will reset the timer for a 2-minute response.
I appreciate Ms. Mendoza's passion, but I do think she exaggerates the testimony of the deputy clerk in the record with saying that he stopped her and interrupted her and prevented her from binding them, and that she was in the process of binding them because there's nothing in the petitions that demonstrates that she had taken any steps to bind them. But beyond that, the Atkinson case was one where a statement of economic interest was filed in one county instead of another in a district that was split between two counties. And the court found that filing a statement of economic interest in one county was sufficient because they actually filed the document and it was publicly available. And I don't think that really has much application here. And I think the board has to be very careful about finding that the deputy clerk can bind the city. And I believe that is a principle of law that has broader application than here. And I think that's going to be a problem.
Thank you, Mr. Mullen. Ms. Mendoza, I'm going to give you the last 2 minutes, okay?
I don't really have much to add other than, as it was stated earlier today, I do appreciate all the residents that took interest in this hearing and that have reached out to me. Again, we rely on the city clerk's office, and there's been a lot of comments on what should be made available and what should not be made available at the office. But again, I think that it was my intent, and again, to my detriment, to rely on it. And it's unfortunate that I will carry that sentiment the next time I step into the clerk's office, and definitely be more mindful and careful of what I rely on.
Okay, thank you, Ms. Mendoza and Mr. Mullen. I believe this can be now turned over to the board to ask questions of the parties and to ask any questions that you have at this time.
Thank you, Kelly. So I'm going to open it up to any comments or questions from Clerk Reader, Alderman Rainey. Alderman Rainey? We'll start. Alderman Rainey.
Yes. Is Eddie here? Eddie Gomez here? Eduardo Gomez? Is he?
I'm here, Alderman Rainey.
Yes. Deputy Clerk, have you ever served on at the time when petitions have been submitted before? Is this your first time, or have you done it before?
This is the first time I'm participating in receiving petitions.
And other than the clerk telling you not to give advice, did you have any training on how to conduct yourself or what to do when people came in with their petitions? Excuse me.
Not directly, no.
So at any time, did you feel that telling people that it's okay, you can submit your petition like this, was actually giving advice?
No.
Okay.
I was just following the direction given to me.
So were you ever told that if people brought in their petitions unstapled or without a ward number on it, that you should tell them that's okay, you can submit that?
My direction was that if someone came in with those circumstances that you stated, to not give any sort of advice, to submit the paperwork at their discretion. And I made sure that folks were made aware of that.
Thank you. Oh, one more question. At any time, were you the only one that accepted petitions during the entire period from beginning to end when petitions were being submitted?
The clerk was there in some cases, but I was the one that was there the entire day.
So it was a week-long event, right? From one Monday at 9 o'clock to the next Monday at 5 p.m., right?
Correct.
So you were the operative. You were the person who accepted the petitions.
Correct.
Thank you.
Clerk Reed?
Yeah, thank you. I hate that, this is turning a bit political here because we have two opponents, but Deputy Clerk Gomez, you just said that this was the first time that you have received petitions. Is that correct?
For candidates that are filing, yes.
Oh, for candidates, okay. But this is not the first time in your time in office that you've received petitions and gone through this process, right?
Point of order. I meant for candidate petitions. I'm not.
Certainly, okay, great. Let's keep going. So this is not the first time you've accepted petitions in the clerk's office, correct? Deputy Clerk Gomez?
Clerk Reed, can you hear me?
I can hear you now. So I didn't hear the answer to that question. This is not the first time that you've received petitions?
Not petitions, no.
Right. And so the filing requirements for as far as binding for candidate petitions is the same as any other petition that comes into the office. Is that your understanding?
Correct.
So, so in fact, this is not the first time you've dealt with petitions being turned in that were required to be binding or to be binded.
Correct.
Okay. Thank you. And then next to Alderman Rainey's question, training. Did the clerk's office this time around has put forward a number of both printed materials and we've done several events, both at council meetings and separately that you are aware of. Is that correct? You've been aware of the numerous trainings that the clerk's office has provided as to the requirements of for candidate filings? I'm sorry, I'm not hearing the deputy clerk or seeing him.
Yeah, I'm not seeing, let me put my, sorry. I'm not seeing him. There he is, he's back. Mr. Gomez, did you hear the question from Clerk Reed?
I did not.
Okay, so I'll repeat the question. So the clerk's office has done a number of trainings beginning back in the spring of last year. We did a town hall where we had several attorneys and someone from the Board of Elections present what the filing requirements for. The clerk's office produced a presentation that, so first, are you aware of that event that took place in the spring, the office event on the 2021 municipal filing? Are you aware of that event?
Yes.
Yes, okay, so you're aware of that event. And so in that event, the clerk's office discussed the filing requirements, including binding, correct?
Wasn't at that event, so I can't say what was and wasn't.
But you had access to the full, you have access to the event, right? Because it's a clerk's office event, right?
Yes.
Okay, and also there was a presentation that the clerk's office provided that includes the binding requirement, and you posted that on the clerk's webpage. Is that correct? Correct. And
answer. I'm sorry, I didn't hear his answer. I'm not hearing all of his answers. I don't know if he's just, I don't know.
I think it's my phone. I'm gonna have to, if you can bear with me, I'm gonna disconnect and reconnect.
Right, and while we're waiting for Mr. Gomez to reconnect, I just remind the board that we are focused on determining whether we think there's been a substantial mistake made here by candidate Mendoza or not.
Certainly. My questions are just based
I see our-
on,
Go
my
ahead.
question. Yeah, my questions are just based on, the questions that Alderman Rainey just answered. And as it seems that that's influencing the determination. So I do want to clear through those things, and then I'm happy to move forward with the, what I think is the more substantive portion of this.
All right, we have Mr. Gomez back. Go ahead, Clerk Reed.
Clerk Reed?
Yes. All right. So we established that you are aware of the training that was done in the spring. You also were aware of the presentation that the clerk's office put together, and you posted on the city's website, correct?
Correct.
Correct. And also, and we also established that this is not the first time you've accepted petitions that needed to be bound. That's correct. And so far as the training, is it the case that I gave you instruction not to give advice to folks?
Correct.
Correct. And then also, is it also correct that for all of the petition filings except those of Ms. Carrillo, Mr. Young, and Ms. Mendoza, that I was present for all candidate filings except for those three, correct?
To the best of my recollection, correct.
Correct. Okay. And yeah, the other day you testified originally that you did not have a conversation with Ms. Mendoza. Is that correct? Before her filing?
I believe what I said, that a part of that conversation didn't take place.
I'm sorry, for the record, you said in response to one of Mr. Attorney Mullen's questions, you said that you did not have a conversation with Ms. Mendoza regarding her filing?
Correct.
Correct.
I believe that's what I said.
Right. And then, but when and the reason we are here is because Mr. Willie Jefferson or Johnson is claiming that Ms. Mendoza did not bind her petitions. That's the reason that we're here, that we were here on Monday, and that's the reason we're here today, correct?
Correct.
And then when Ms. Mendoza asked you and said, gave her testimony that you in fact had given her that advice, you then changed your testimony, correct? You then said that, oh, well, yes, I did tell you that you could turn them in as they are. Is that correct?
No, that's not correct.
Oh, please correct the record. What did you say at the last meeting that you told her?
So I believe what I said was that when she asked if she could turn in her petitions the way they were, I was paraphrasing and saying that she could turn in the petitions as they were, but it wasn't advisory in any way.
Okay. And Ms. Mendoza she testified earlier that she was seeking materials to potentially bind her petitions. Do you recall that?
I recall that she just stated that, yes.
No, do you recall her seeking the materials while in the office?
No.
No. Okay. Well, thank you, Mr. Gomez. Those are the questions that I have for. Oh, and those are the questions I have for you. Ms. Mendoza.
Yes, go ahead.
Hi. I know you're not represented by an attorney, so I will ask, were you aware when you filed that, what the requirements of binding were?
I was.
Oh, okay. So you were aware that you had to bind your petitions and what that meant?
I was.
Okay. I have no further questions.
Ms. Mendoza, because you mentioned this at the last hearing, and I think it's relevant. Walk us through again when you came into the Civic Center with your papers and they weren't, bounded. Take us through exactly what happened, what you asked for, if you asked for anything.
Yes, I showed up at the Civic Center around 1 o'clock and went up to the city clerk's office on the second floor. There was nobody.
So can I stop you? I'm sorry. Can I stop you right there? So was it not in G? Okay, but there was nobody there. Go on. I'm sorry, because I know Eduardo had previously reported they were doing this downstairs in G300.
Correct. So there was nobody in the office from 1 o'clock to 1:30. I waited for 30 minutes. It said that the office was closed, but I couldn't understand why the office would be closed on the last day of submitting filing. So I waited for 30 minutes and then I left the building and headed to my car. As I left the building, I noticed that the deputy clerk was coming out of his car. And so I followed him back into the Civic Center, at which time we walked together to the basement floor through the basement where the alternate location was being held. I don't know the room number, but it's on the north end of the building. Once we got to the table, I took out my paperwork and I asked him if he had a stapler. He said, no, we don't have a stapler. There was several different items on the table, including at least half a dozen fasteners and the printer, as well as pen and paper on the table. I then stepped back and started searching through my pockets for a pen because I saw that there was fasteners there. And so I was in the process of looking for something to perforate my paperwork, at which time I was interrupted. And the clerk said, it's okay, you can hand them in that way. At which time I stopped what I was doing and I head back to the table and I turned in my paperwork as was instructed by the deputy city clerk.
Deputy Clerk Gomez, could I ask a couple questions of you?
Yes.
Were there fasteners on the table?
I don't recall, Mayor Haggerty.
Okay. Do you recall if candidate Mendoza was working to puncture her papers so she could put something through them?
No.
You don't recall? Okay. Were you under any instruction not to provide a paper clip or a stapler to any candidates that came in?
Yes.
Yes, you were under instruction not to provide that. Whose instruction?
Yes, correct.
Whose instruction? Whose instruction was that?
The city clerk.
Okay, so you're saying the city clerk said not to provide any candidates with paper clip or a stapler if they need that. Am I hearing that correctly?
Well, he said to not have those items available in the room.
Okay. How long have you worked in the clerk's office?
A little bit over 3 years.
During that time, people come in to conduct business in the clerk's office. Is that correct?
Yes.
Has anyone during that time come in and ever asked for a paper clip or a stapler to, put documents together?
I can't recall, but yes, it would be reasonable.
Okay, but you don't recall. Okay, so I won't go there next. Can you take us through the process once Ms. Mendoza turned over the papers to you? What did you do next with them?
I simply took them to be scanned and uploaded to the Google Drive.
Ms. Mendoza, have you seen the documents that were scanned and uploaded?
Not the entirety of the documents. I've in the documents that were emailed to me after Monday, it only included the first page.
Okay. Deputy Clerk Gomez, have any papers been added or subtracted from what candidate Mendoza submitted to you?
No.
No. Okay. Ms. Mendoza, have you submitted or subtracted any documents submitted from your papers on that day?
I have not.
Okay. Mr. Mullen, is there an allegation? And I understand the argument about securely fastening documents, but I just wanted to know, is there any argument made on the objector's part that there has been fraud in any way related to the documents submitted by Ms. Mendoza?
No.
All right. Okay, that's all the questions that I have. Thank you, Deputy Clerk Gomez and Candidate Mendoza. Is there any further discussion among board members? Clerk Reed.
Yeah, I have a few questions to help me make a determination here. And to, I think, help the board make a determination. Deputy Clerk Gomez.
Yes.
You just testified that I instructed you, the mayor asked a specific question and said, you know, did the clerk instruct you to not, or did someone, and you identified the clerk as the person who gave this instruction, did someone specifically instruct you not to have a paper clip or, you know, a stapler available? Is it so your recollection is that I specifically told you not to have a stapler or a paper clip or anything available, or is that correct? That's your recollection?
Yes.
All right. I dispute that. But to the facts here, Mr. Mullen.
Yes.
You are, you know, I think folks would consider you a seasoned election attorney. You've dealt with, I don't know, how many, roughly how many election cases do you think you've, you know, dealt with over your career?
430, according to my spreadsheet.
430. And I'm sure a number of those were, you know, you potentially filing on behalf of a candidate?
Yes. Yes, I represent many more candidates than objectors.
Okay. And you've done this in multiple jurisdictions, is that correct?
Yes.
Okay. And in any jurisdiction where you have filed petitions, have you seen the practice that, you know, folks come into the election official's office with their papers, you know, unbound or unpunctured, and they come in and then the office that they're filing with provides hole punches and staplers and markers and scissors to prepare their petitions? Has that been something you've witnessed?
The State Board of Elections does not do that. The Cook County Board of Elections, I have not seen that. And I believe the Chicago Board of Elections does not do that. But beyond that, I typically am not the person who goes and files the petitions, other than, you know, the first day when you have, you know, a dozen or so candidates filing. And my recollection is no, that those are not usually available.
And the state statute says that once petitions are submitted to the election official, they're not to be altered or changed or have any additions or subtractions. Is that, you know, roughly correct?
Yes.
And so for a candidate to, you know, come into the office to submit their petitions, potentially set the petitions on our table and, you know, then staple them or, you know, bind them in some way or number their pages or do anything to alter their petitions, would that seem in violation of the state statute for someone to, you know, submit their petitions and then alter them by stapling or some other means?
So are you asking if someone puts their petitions down on the clerk's counter and the clerk staples them, is that a violation of the law?
Or the candidate staples them, or anyone staples them? Would that be a violation of the law?
After the clerk has taken possession of them, I think it would be. But, you know, now you're getting into factual issues. But I think once the clerk physically has possession of the petitions and the candidate has released possession of the petitions, then they cannot be stapled after that.
Ms. Gandersky,
Yes.
we asked earlier with the case earlier with Mr. Young, you mentioned that if there was a question as to the manner of filing, or actually, Ms. Mendoza, I do have a question. Were your petitions in a folder, or was there, I think you did testify that there wasn't an attempt made to bind the petitions, correct?
They were in a sleeve.
Oh, they're in a sleeve.
They were in a sleeve when I brought them in, yes.
Did you turn them over in that sleeve?
I did not.
All right, thank you. That concludes my questions.
All right, thank you, Clerk Reed. If there's no further discussion among the Electoral Board, is there a motion that anyone would like to move? The motions available to us is to sustain the objector's objection or to deny that objection. Alderman Rainey.
I move to deny the objection.
I'll second that. Any discussion? All right, seeing none, the motion on the table is to deny the objection. Alderman Rainey.
Aye.
Mayor Haggerty is an aye. Clerk Reed.
Aye.
All right, so on a 3-0 vote, the election board is denying the objection put forward by Willie Jefferson and represented by Ed Mullen. Ms. Gandersky, do you just want to note what will happen next?
Yes, we can do the same thing we were doing in the last case. If you want, we can draft the order this evening, reconvene tomorrow. I don't know if Ms. Mendoza wants to come back. If she wants to waive coming back, we can mail it to her and email it to her. Same with Mr. Mullen. So that's the option, or you can come back tomorrow morning. We can issue the order then.
But either way, just so we're clear, the board will be reviewing it tomorrow morning and will vote on that actual written document, presumably as we just voted today, because that's how the document's going to be written up. And so Ms. Mendoza can be there for that and see the vote, or get it emailed to her right after. Is that correct, Ms. Gandersky?
Yeah, the votes happened, so it's really just agreeing on the language of the order.
Gotcha. Okay. Is that clear, Rebecca?
Yes, I would just like to take a moment to say thank you. And I am completely okay with receiving it via email.
All right. Thank you both, Ms. Mendoza and Mr. Mullen, for the representation of Willie Jefferson. We have one more case to handle, and that is on the docket for tomorrow morning at 9 a.m. I think we expected this session would go longer because of the Harned versus Grover case, but Ms. Grover agreed with the objections that were filed and that a mistake had been made, and so she pulled out. So that case for tomorrow is Evie Russell versus Eleanor Revelle. I presume that Alderwoman Revelle and her attorney are not here, nor are Evie Russell. I see, it looks like Evie Russell's with us today. but I'm presuming her attorney.
Actually, Mr. Mayor, this is Mike Kreloff, attorney for the candidate. I think we're all here except Andy Finko, and we're fine since you're convening tomorrow morning anyhow. And Mr. Finko presumably has somewhere else that he's at today.
Well, okay, Mike, let me ask you this. If our attorney reached out to Mr. Finko and he were able to argue the case right now, since we had set aside to 4:30, would you be willing to argue Ms. Ravel's side of it right now?
Yes, Ms. Ravel is on here. I think she's fine also. Okay. I have to go put my tie back on, but.
All right, but let's see if we can reach Mr. Finko and he would be willing. Because if either party doesn't want to, then we'll convene at 9. We're still going to have to convene at 9 to do those, but I'd love to handle the cases today since we still have time today. Ms. Gandersky, could you read? Yes.
Mr. Finko is available.
Okay, terrific. Thank you, Clerk Reed. Then I would just ask then if the parties could put your camera on when you're here so I can see that everybody's here, and then we'll have Ms. Gandersky move us through the procedures of this case. And the case then that's upcoming that we'll be hearing is number 9 on our agenda today. It's case number 20-MOEB as in boy -EV-07 Evie Krause Russell versus Eleanor Ravel, who is a candidate, has put in petitions to be a candidate as the 7th Ward Alderman.
That's correct. I just want to remind the board, I know it's been a long day and a long week. We still do have public comment on the agenda, so that can happen today or tomorrow morning, just for the board to consider and keep in mind.
On that, can I just ask Clerk Reed and Alderman Rainey, if we do go into public comment, I have a hard stop at 4:30. Oh, you do too.
I can be available. Oh, okay. Well.
All right, but we don't have quorum, so we won't have.
We need quorum not for public comment. According to Open Meetings Act, it's to conduct business. So I could sit here and still hear the public comment.
Oh. Let me ask this, Luke. Is Luke Stowe with us? Do you have a sense of how many people, if any, have signed up for public comment today?
Hi, Mayor. There are 3 people currently signed up that I'm aware of.
3 people. Okay. All right. Is that, Ms. Gandersky, do you agree with Clerk Reed's interpretation? Then we wouldn't have to have quorum here for public comment?
Right? No, I just got it.
Sorry, I think Mr. Mullen's on. I'd like to look up that rule on OVA. I don't know that we can't have a quorum for public comment, but I'll take a look at it, or I'll have Ms. Ruggie take a look at it while we're doing this. But all right, are we ready to call the case in any event?
I don't see Andrew Finko. Is Andrew with us? Kelly, do you see? I don't see him here yet. Do you? All right, so let's wait for Mr. Finko and then we can start.
Oh, I just received a message from Mr. Finko. He's actually not available for the case now.
Oh, okay. All right. So I apologize for that. And then everybody, Mike, you don't have to go get your tie on.
All
right. We will convene. We're going to recess and then reconvene tomorrow morning at 9 a.m. The first things we'll handle there are.
Mayor, I'm sorry. Do you want to do public comment now? Since
yeah,
we just have to do it tomorrow.
If we can, I think that's fine. That makes sense. All right. So Luke, if you don't mind, if you could call off, since I don't have the list in front of me, the 3 individuals that will be at public comment right now.
Mayor, one of the speakers is Carla Thomas. I believe she is with us.
And who are the other 2, just so I know?
Allie Harned and Larry Donahue.
All right, thank you. Ms. Thomas, if you're here, you've got the floor. Welcome.
Hi. I
Most people who know when I show up, hi, I'm Carla Thomas. I'm a citizen here in Evanston in the 2nd Ward. Whenever I show up, I generally show up to talk about race and equity. And I wanted to simply put a lens of equity on all of the discussions that were had today. You all might want to sit down or mark this day in history, but I have to say that I agree with a lot of what Anne Rainey said today. Not pertaining the political rant and that piece of it, but we are stood a lot on the law today, and I know this is how this country works, but we also need to remind ourselves that the law doesn't equal what is right. The law has never sided on the side of equity. The law once made slavery legal. Sitting here and kicking people off the ballot because they had the letter, that they refused, they didn't put the number 8. When, hello, it's 2020, anybody can Google somebody's address. Everybody on the city of Evanston knows where that person lives. And then wasting city time to discuss whether a staple, clamp, look, I am not a lawyer and I know these things are in the letter of the law. But if we in Evanston want to say that we believe in equity, we have to not only say it, but we have to act on it, which also means we need to put things in place, if we still have to follow the law, to make sure that less people fall through the hoops. If we want this to be a place where everybody has the chance to run for office and be on that ballot, we cannot let stupid crap like a paperclip and a clamp and a hole keep us back. So next election, we as a city government, a city group, need to do better about making sure that people aren't pulled off the ballot for stupid crap. You know, double checking that somebody's signatures are all correct. That's about fraud, potential fraud. I'm not saying anybody had any fraud, but potential fraud and things like that. That is, to me, a valid check. But whether somebody had a stapler and whether somebody missed the number 8 on their, yes, that may be the letter of the law, but that is not the spirit of equity. And that's not what Evanston is saying they stand for in terms of making the ballot and making positions of office accessible to everybody. And I'd like you to note that the people who were able to show up with lawyers today are the white folks. Just saying, notice, right? So we could say everybody has access. We could say everybody should know the rules. But when you're focused on rushing to get everything prepared and you forget a freaking stapler, that should not be the difference between you getting the ballot and not. Thank you.
Thank you, Ms. Thomas. Next speaker is Allie Harnan.
Hello, can you hear me?
We can hear you. Welcome.
Hi, thanks. So I want to say that I really appreciate the work of the residents who have stepped up and done the work to get on the ballot. And I know that having collected many signatures myself for various referenda and candidates, that it is a considerable effort to be able to get on the ballot. So I really congratulate the people who were able to do that. And I want to say that this electoral board process, now I've gone through it 3 times. I really question the validity of, not validity, I guess the honor of having a local electoral board that is made up of people who, like it or not, have political ideas that are driving the decisions that they're making. And so is it really fair? Is it really just to people who are coming before this board to have decisions made by people who are biased? And, clearly the law can be applied various ways because we have substantial effort being interpreted one way for one candidate and another way for other candidates. So I think that that's something that we as a community need to think about and really work hard on. I also want to say that I have had experience going into the clerk's office to submit petitions and an objection. And I made very sure that I was doing it right because I didn't want to do it wrong by some procedural thing. And so I invested in my own 2-hole punch, and I am willing to share this with anybody who wants to be a candidate in the future. It's very handy. And I have binder clips, and please let me know if you need some help getting on the ballot in the future. And I also want to say to Ms. Grover that I appreciate the effort that you put into being a candidate, and I appreciate that you didn't want to take any more resources in fighting a battle that would be very difficult to win. So I appreciate everybody's efforts in this, and I hope that we can be fair and just in the future and have some great elections in February and April. Thanks very much.
Thank you, Ms. Harned. Next speaker is Larry Donahue.
Mayor, I'm not sure that speaker is with us at this time.
All right. So what we'll do is after we finish next on Friday, tomorrow, if Mr. Donahue's here or anyone else is signed up for public comment, we'll let them speak then. All right. Ms. Gandersky, oh, Mr. Reed, you're muted.
Did not realize I was muted. I just want to make a closing comment. I suppose that's what's coming next. And, you know, our democracy is sacred. And it is extremely important that folks follow rules. I think the board, in the cases that we've heard thus far, or that I've been a party to, you know, seems, I feel as though we've been fair. You know, I do want to note that, you know, there have been a lot of arguments made about the clerk's office and staplers. For the critics and the folks who are out there, I would challenge you to look up any clerk's office, any other local election official's office in the state of Illinois, and find me a clerk that has given out more information about the procedure for filing for office than the Evanston clerk's office. We've done events for the last 6 to 8 months, giving folks the procedures for getting on the ballot. We have done a number of presentations at the city council during council meetings that someone running for alderman, I would suppose, would watch, that included the requirements. We have put out publications, and I think
Clerk Reed, I don't, unless each of us are going to make some kind of campaign or political speech. Yes, I believe you are. I think we are here to hear the cases. We have heard the cases. We're about to recess, and now you want a platform to talk about all that you've done. That is not what this proceeding is for.
Then Alderman Rainey, okay. Thank you, Mayor Hagerty. Thank you.
All right. All right. So we are going to recess until 9 a.m. tomorrow morning. We will look at the documents prepared by the attorney first, and then we will hear our final case, which will be case number 7, which is Evie Krause Russell versus Eleanor Revelle. So we'll see everybody at 9 a.m. Ms. Gandersky, anything that you need us to do or think about this evening?
Just a motion to recess to tomorrow morning in a second and a vote.
All right, I'll take a motion to recess. I'll move a motion to recess. Is there a second? Does Clerk Reed or Alderman Rainey want to recess? All right, Clerk Reed does not want to recess. So Alderman Rainey, are you a aye for that?
She's not.
She's
muted. She's muted.
Can you unmute?
Aye.
Okay. All right. So we're going to take a roll call on recessing. Alderman Rainey?
Aye.
Mayor Hagerty's an aye for recessing. Clerk Reed?
Aye.
All right. All right. So 3-0 vote. We're going to recess. We'll see everyone at 9 a.m. tomorrow morning. Thank you, everyone, for all your hard work today. Bye-bye.
Thank you.